We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, and welcome to today's remote sitting of the Appeals Court. I'll begin by introducing the panel to you. My name is Ariane Vuono. I'm joined today this morning by Justice Peter Sachs and Justice Catherine Hand. I want to give you two quick reminders before we begin. First, the rules regarding oral argument apply to remote sittings just as they would if we were in the courtroom. So each side has 15 minutes and there is no rebuttal. And second, upon occasion, we do experience some technical difficulties. If so, they generally can resolve pretty easily, but we ask for your patience and we promise to be patient with you. Attorney Orrin, before I call your case, I just want the public to know that you will not be actually appearing in terms of a person as a square, but your voice will be heard because you're arguing via telephone. I just want to check with you that you feel comfortable with that and that you feel that you are communicating with the panel.
Yes, thank you.
Great, thank you very much. Okay, so now I'll call the first case, which is Commonwealth versus GLENROY Miller, 2019-1747. And Attorney Orrin, you may begin.
Thank you so much. I'm Catherine Orrin for GLENROY Miller. Miller ranks among countless car passengers subjected to investigation because of someone else's driving. And police here were candid that traffic stops are pretext for criminally investigating chance detainees, which they did. Now, Miller agrees with the Supreme Court in Terry that no law obliges anyone to risk lives, much less police. His position in this case is no other. His position is that he agrees with this court, though, in cases like Hawley and Hooker, that horse sense in Terry doesn't mean that passengers can or must freeze to repel inquests during someone else's traffic stop. So the question is, when exactly does inevitable movement support reasonable suspicion of armed danger? And of course, this is highly fact-driven. In the aggregate, police here, though, assessed armed movements and lifted hips seen while approaching the stopped car on a thoroughfare in a place known for gun crime. And that makes aid most closely on point, that such movements justified exit order and frisk. As a threshold matter, though, Minade is materially distinct from this case in at least three ways. Miller, unlike Minade, kept his arms fixed, crossed, and foreclosing any means of pulling a weapon. And police admitted no possibility of pulling a gun, with Miller's arms crossed and fixed that way. Now, Miller further, unlike Minade, had no need to move around to get stuff for traffic stop inquiry, and Minade mobility posed a potential threat that Miller's fixed and crossed arms foreclosed. And finally, Miller was a mere passenger.
Excuse me, Ms. Orrin.
Yes.
This is Judge Sachs. May I ask, even if Mr. Miller had his arms crossed at a particular moment, it doesn't take very long to uncross one's arms, and if one has something concealed in one's pants, to pull it out. Would you agree?
Sure, I understand. And the officer is standing right there, and Miller is very, very clear. He's not moving his arms at all. He's put them on display in a fixed, crossed fashion, and police understood it in exactly that way. And they understood further that he didn't have to move around, unlike McCall, the driver, or Minade, just to get stuff. So there was no potential threat on that score. And plus, he was a mere passenger. He didn't control anything, unlike Minade, again. And Miller was as threatened by McCall's bad driving as anyone else. Now, beyond those threshold distinctions, no one could infer armed danger from refused conversation and eye contact. Police knew no one in that car. They had seen no crime. No law tasks traffic stop passengers with police communication at all, much less forces them to submit to Dragnet investigation. And even police conceded that conversation here wasn't conversation. It was roadside inquest of chance detainees with an eye to finding crime. And nor finally, labored breathing and anger at bad driving. That didn't suggest armed danger. Any rational person would be rattled by reckless operation. Then surprised inquest based on trapped passenger status. Now, this court had it right.
Even, Ms. Orrin, if I may, even if we put aside the defendant's manner when the officer approached and the defendant got irritated with the driver for having driven with no headlights on. And even if we put aside the officer's testimony that this was a high crime neighborhood that involved gun crimes in the past, MINASIan says that the defendant's unusual action of lifting himself off the seat by 6 inches in a manner consistent with concealing something was sufficient to justify the exit order and pat frisk. So that fact alone was sufficient, aside from high crime area, aside from defendant's manner when approached. So
no, that's right. And that's what makes MINASIan, but no, nobody talked about MINASIan until Miller brought it up and brought it to the court's attention. And it's a problem because the way that the facts were decided there, he just lifted himself a little bit off the seat, and there was really not a whole lot of some arc movement. And the court really, if you think about the Hawley case, for example, which is instructive, is at the middle of the night stop. It's 10 a.m., 1:10 a.m. in the morning, and the driver, that's Hawley, he's weeding all over. All of a sudden, he leans dramatically over to the right side, and police are concerned he's concealing, he might be retrieving a weapon. They stop this guy, Hawley, in a place known for gun crimes. Hawley's nervous, and he's sweating, even though it's a cold night. Now, even in the aggregate, given that dramatic leaning, all of this stuff, that wasn't enough for reasonable suspicion because Hawley, it's not one of those cases like that are listed in Sibling, where he's ducking down out of sight for some period of time, popping up, and who knows what's going on there. And what this court stressed in Hawley is that even this dramatic leaning over, it's in, the police can see him, that really couldn't be considered a furtive gesture, because if it were, virtually any gesture, no matter how innocent or trivial, leaning over could be interpreted as a furtive gesture.
Well,
and
sure,
so
there are.
Calling on,
Yeah, there are gestures and gestures, but this particular gesture was the defendant sort of hoisting his body up off the seat to the point where the officer behind the car could see his hips, which is not a small distance.
If it's up over the top edge of the seat, it's a remarkable claim because his hips is almost touching the roof of the car. And I understand that officers behind the car, and they see some lifting of hips. And that's why, MINASIan is the issue. That's the main case here. And again, we do have multiple material distinctions because even after MINASIan was talking to him, he could still move around, right? And he didn't have his arms fixed and crossed that way, and he controlled everything. In fact, his control of the car had brought police down on him to begin with. And all of those.
Can I ask you? This is Judge Vuono. I'm having trouble understanding what the significance is about your client not having control over the car, and how that factor supports your view of the fact that the exit order and the pat frisk were not reasonable.
Well, there are some cases where the driver could lunge forward, something like actually control the car and pose a threat that way. And the point here is that
because of the actual car, because of the car maybe losing control of the car or something like that. Is that what you mean?
Or just using the car to escape or to lurch forward.
I see.
Cases like that. And so here, what's essential is that Miller really was no more than a passenger in that car. He controlled nothing. He brought nothing down on him. He went out of his way to put this display on. The police understood it in exactly that way. Crossed.
But may I ask you this? Certainly, if there was a weapon in the car, of course, the police don't know that before they conducted the pat frisk. Your client would have had as much control over that if it was within his area of the car as anybody else in the car, as the driver or anybody else.
Well, not according to testimony. With his arms crossed and fixed that way, he couldn't pull a gun. And so, of course, it's a theoretical possibility. He could whip his arms all of a sudden, and the cop couldn't stop him from the outside. But that's not what this is about, reasonable suspicion, and not what's theoretically possible. And so what's essential is that cases like Hawley and Hooker, detainee movement is inevitable, especially since police make people nervous. And even so much as eye contact becomes a dangerous tightrope act. Too little or too much, according to unknowable officer taste, it's enough to unleash public police inquest. And that's what's happened here. Our constitutions require no paralysis to repel roadway body search along with the public shame of being manhandled and open suggestion of criminal status. And even police admitted no violence, crimes, deceit, no threats suggested danger. Now, given their admissions, fleeting fidgeting rose to no level of reasonable suspicion, and any suspicion was then logically undone by fixed folded arms for closed weapon use.
Attorney
And
Warren,
foreclosed
this is
weapon
back
use.
in hand.
Yeah.
Could I ask a quick question? Am I correct in
Sure.
understanding that you are not claiming error as to any of the facts that the judge found, correct?
I don't find any plain error. The only thing is that it was this enough, the fact that there was this lifting of hips and moved arms followed by fixed folded arms that police conceded foreclosed weapons use. And Miller's position is that foreclosed weapon use couldn't justify any public roadway shaming of a traffic stop passenger. And so it's on these grounds he's asking the court to revisit MINASIan and application of Terry doctrine to facts in this case.
Attorney Warren, just so you know, you still have 5 minutes if you have anything else
I
you want to add.
understand.
Okay.
And Miller, I think if the court has any questions or concerns, he's happy to address them now.
Okay, just one moment. I'll just check with the panel to see if they have any additional questions for you. They do not. So I thank you very much for your argument. I'll now turn to, I guess I can't say Attorney Morgan, right? But because that hasn't happened yet, but you're a law student that is now has legal court to argue for the Commonwealth. Welcome, and we're ready to hear your argument.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. Taylor Morgan on behalf of the Commonwealth, arguing with leave of the court. With me today is Assistant District Attorney Monica De La Tour. We are respectfully requesting this court to affirm the denial of the defendant's motion to suppress. The motion judge properly denied the defendant's motion to suppress because the exit order and pat frisk of the defendant were justified based on the following 3 facts. First, the traffic stop of a car speeding with no headlights on at 3 o'clock in the morning in an area in which the officer had specific firearm experience. The second, the defendant's furtive movements as officers approached the vehicle before the traffic stop. And the third, the defendant's increasingly agitated demeanor during the traffic stop. This traffic stop.
Let me ask you, Ms. Morgan, right from the get-go, if I may, excuse the interruption. What do you do with the fact that Commonwealth versus Torres Pagan was decided after this case, and that arguably shifted the focus on the justification for a pat frisk? What do you say about that?
Although Torres Pagan was decided after the motion judge made the findings of fact, the motion judge's ruling was consistent with Torres Pagan because Torres Pagan held that in order for a pat frisk to be warranted, the officer must have reasonable suspicion based on the totality of the circumstances that the defendant was armed and dangerous. The motion judge did decide consistent with that. However, the court is deciding that once again in this particular case. And in this case, the officer did have reasonable suspicion that the defendant was armed and dangerous based on the objectively reasonable belief that there was a concern for officer safety. The furtive movement is particularly instructive in this case, consistent with MINASIan, and this case has more factors than were present in MINASIan to justify the exit order and pat frisk, namely the increasingly agitated demeanor of the defendant and the officer's particular experience with firearms within 2 blocks of where the traffic stop was made. The officers.
If I may ask, Ms. Morgan, the reliance on this stop having occurred in a high crime area is a factor that the courts have said should be considered with some caution, because obviously people who happen to live in those areas or pass through those areas have the same constitutional rights as everyone else to be free of unreasonable stops and exit orders and pat frisks. So do we need to rely on the place where this incident occurred in order to affirm your position and affirm the order?
The court need not rely only on that particular fact. In fact, it's not necessarily that the area was high crime generally. This particular officer had specific experience making firearm arrests within 2 blocks of this traffic stop himself. So when he found himself in this particular area, once again, it was reasonable for him to believe that this area could pose a particular threat after specifically seeing that furtive movement. But luckily, the court need not only rely on the high crime area. It is the furtive movement, the defendant's demeanor, and also the fact that this officer has that specific experience with firearms, specifically in that area.
Do we need to rely on it at all?
The court may use it in its analysis. It's a factor to consider, among others, to legitimize law enforcement concern for danger. However, it is not necessary alone. So this particular furtive movement was one where the defendant raised his hips off of the seat, tucked his head, and shuffled his shoulders around in a manner where the defendants could, or the officers, I'm sorry, could not see the defendant's hands. The officer's main concern, and the main concern with any sort of unusual movement in this way, is that the officers cannot see the defendant's hands and that the defendant could possibly be retrieving or concealing a weapon. The Monade court specifically said that this kind of danger is inherent in every kind of traffic stop, especially when the defendant makes a sort of furtive movement. And while an agitated demeanor or a nervous demeanor alone is not by itself enough, in the Brown case, the court stated that when coupled with other factors, and the court specifically said when coupled with a furtive movement, for example, the officer may have reasonable suspicion that the defendant is armed and dangerous based on an objectively reasonable concern for officer safety.
Do you read the findings as suggesting that the officer could actually see the defendant's hips above the level of the back of the seat, or is the officer just drawing an inference from the way he can see the defendant's upper body moving, that the hips are being raised off the seat in a way that was either concealing something or retrieving something?
I would have to say the latter, Your Honor. The officer was using his training and experience in furtive movements or unusual movements in this manner to see that the shoulder shuffling, the head and the shoulders bending toward one another was consistent with this sort of movement and raised a concern for him for officer safety. However, the exit order did not occur there. That particular concern was specific to the defendant because once Officer Starkey, the officer who testified at the suppression hearing, came to the passenger side of the vehicle, after observing that unusual movement by the defendant, the officer then observed the defendant breathing heavily, breathing rapidly, his arms crossed, and defense counsel is correct in that alone is not enough. However, when the defendant exclaimed with an expletive, "You had your effing headlights off," this raised the officer's concern that the defendant could pose a danger and was clearly angry, according to the officer at the suppression hearing.
Is the anger itself what causes him to have more reasonable suspicion, or is it some inference that because the defendant is getting angry, he's got something to hide?
It is the anger that is combined with that unusual movement, almost as if there's some sort of dissatisfaction with the fact that they were pulled over and that the defendant could have been concealing or retrieving a weapon. This officer stated that at that point, he asked the defendant out of the car. And this was during the traffic stop. So as the other officer was in the cruiser running the IDs and registration on the car, Officer Starkey asked the defendant out of the car in order to pat frisk him for officer safety purposes, as he had a reasonable suspicion based on the totality of the circumstances of the encounter that the defendant could have been armed and dangerous and posed a threat.
Does it matter that in Monade, the defendant was the driver, whereas here the defendant is the passenger?
The Commonwealth does not believe that it's instructive that the defendant was not the driver. Regardless of whether the defendant is the driver or the passenger, any sort of unusual movement, especially one where the defendant could conceal or retrieve a possible weapon, no matter their placement in the car, still poses an inherent concern in traffic stops, as the Monade court stated. The defendant could have very well concealed or retrieved something as the driver in Minade or as a passenger in this particular case. There are more factors here in this case than there were in Minade, and the court should look at the Minade court's ruling that the furtive movement alone was sufficient. Here, if there are more factors present that this court has historically found when aggregated together with other factors, creates this reasonable suspicion that there was enough reasonable suspicion in this case to justify this exit order and pat frisk. Further, Minade was actually—
I just have one question for clarity, if I may, and that is, the judge here did not specifically find or specifically conclude, perhaps is a better way of putting it, that that the officers had reasonable suspicion to believe that the defendant was armed and dangerous. What the finding was is that there was a reasonable suspicion or concern for officer safety. What do you say about that? Is your point that that's a conclusion of law that we can come to on our own based on the facts as they're found, or does that pose a problem?
That should not pose a problem for the court, specifically after the ruling in Torres Pagan was more specific as to the standard for a pat frisk, that the defendant needed to, there needed to be reasonable suspicion as to that specific defendant, that the defendant was armed and dangerous. So if the officer had a concern for officer safety and had reasonable suspicion on that basis, and the court finds as such, then the court may use Torres Pagan as an instructive case to note that if the officer had reasonable suspicion that the defendant was armed and dangerous, thus warranting a concern for officer safety, then the court should affirm the denial of the motion to suppress. Additionally, the Minade case was affirmed by an unpublished opinion, Fernandez, 95 Mass Appeals Court 1116 in 2019. This panel included Justices Rubin, Sullivan, and Nyman, and this case included that similar hip-raising gesture. And they used Minade to note that there was a reasonable basis to believe that officer safety was in danger because of that officer's reasonable concern that a plausible explanation for the defendant's movements was the securing or concealment of a weapon. So although that was an unpublished opinion, I note that specifically because this court has affirmed Minade in this other case with a similar hip gesture. This reasonable suspicion was specific to this defendant, and the officer treated it as such. The other people in the car, the passenger and the driver, they were making conversation with the officers, and while the law does not require someone to make conversation with officers during a traffic stop, this unusual and different demeanor of the defendant, especially after his exclamation as to the driver's headlights, raised a concern to the officers that the defendant could have been armed and dangerous after observation of that furtive movement of the hips. And if this court has no further questions, the Commonwealth rests on its brief. Thank you very much.
Well, you're welcome. One moment, I'll just check with the panel to see if they have any follow-up questions for you. And I don't see any. So I thank you both very much. Thank you, Attorney Oren, for appearing by phone. We appreciate it. Thank you, Ms. Morgan. And thank you also for being here, Supervisor Delatour. Thank you.
Thank you very much.
We are live.
Okay, thank you very much. And good morning to both of you. My name is Ariane Vuono. I'm joined this morning by Justice Peter Sachs and Justice Catherine Hand, and welcome to today's remote sitting of the Appeals Court. Two quick reminders before we begin your argument, and that is the rules regarding oral argument apply to remote sittings, just as if we were sitting in the courtroom. And second, upon occasion, we do have some technical difficulties. And if that happens, they're generally resolved fairly quickly. And we will be patient with you. We hope to be patient with us. I'm going to call the case now, Commonwealth versus John Harton, 2019-1143. And Attorney Redgate, you may begin your argument.
Thank you, Your Honor. May it please the court, I am Russell Redgate. I represent the defendant, John Harton. And of course, subject to any questions the court might have, my own intention would be to principally address 2 of the 5 claims defendant presented. That would be the first, which has to do with the introduction of evidence from a former girlfriend of defendant to the effect that he sometimes had difficulties getting sexually aroused with her, and the implication being that he would be attracted to small children. And that was made explicit at the time defendant objected, which he did to that testimony. The other would be the last claim, that is the use of a one-sided first complaint where no first complaint witness appeared, but testimony was given by the complaining victim witness that he had disclosed to his mother, who was then deceased. So those 2 would be principally what I'd like to address. Then if time permits and things go smoothly, I'd address 2 others. But the 5th claim, which is number 4 on the list, by leave of the court, if the court grants it, I would like to withdraw that claim now because it alleges an error of counsel. And I think I have to concede that that basis for that does not appear indisputably in the record. I think it's not as firm as it might be and would probably better be presented, if at all, on a motion for a new trial. So that would leave us with 4 claims, and I'll begin with the first. Defendant
did clear, Mr. Regia, that's the juror claim?
Yes, juror number 11.
Okay.
As to the first claim, there came a time when the prosecutor had a witness on the stand, Dawn Gates, a former girlfriend, fiance, in fact, of the defendant, and she was asked about were there sometimes sexual difficulties between you and the defendant, and defendant objected. And the court, he objected on the grounds of relevance. Now that point had been discussed fairly thoroughly on motions in limine, not with regard to Dawn Gates, but in general, the idea of defendant's sexual orientation being introduced in the trial. The judge was very clear and very strong that this would be irrelevant and it would be highly prejudicial.
But then the defendant later said, I'm going to bring the defense counsel said, defendant is highly likely to testify, highly likely to talk about his sexual orientation. Therefore, I want a voir dire question of the jurors as to whether that would impair their ability to be fair and impartial. And so the issue was back in the case. Was that safe to say?
Well, I think it's close, but not quite accurate, Judge. The defendant's counsel did tell the judge that it was likely his client would testify. He may have said very likely, highly likely, but he did say yes, and he thought it was likely that the defendant would disclose his homosexual orientation. But it was the judge, not the defendant, who proposed the instruction. The defendant did acquiesce, and he, in fact, accepted language, which I think was inartfully drawn. It said, would the fact that defendant now identifies as a gay man affect your ability to be impartial? How much better it would have been to say, if there were evidence that defendant identifies. Nevertheless, there was no objection. Defense counsel did acquiesce, but he wasn't the one to introduce it. And secondly, it was never mentioned before the petite jury. Once the jury was in the box, defense counsel very wisely refrained from mentioning not only that point, but from mentioning that the defendant would testify. So there was absolutely no suggestion of that in the trial record before the petite jury at the time when the prosecutor sought to elicit that testimony. And defendant immediately objected. He never changed his position on that. And the judge seemed to change her position radically to say, oh, I see a big relevance, and to explicitly say what the relevance was, that he's got trouble getting aroused with his fiance, and he's alleged to be attracted to young boys. Presumably that inference would be drawn. Exactly the inference the judge feared in preliminary discussions on the motion in limine.
The judge may have said that at sidebar, but when the Dawn Gates answered that question, she didn't draw any such connection between whether the defendant had difficulties becoming aroused with her and whether the defendant might be gay, let alone attracted to young boys. So that's two inferences that could have been made conceivably by the jury, but the same inferences could have been made from your client's testimony later that he was or now identified as gay.
Well, possibly if the defendant had so testified later, but that's a decision that's always in the defendant's hands, not counsel's hands, and he can make it at any time. It was wisely not mentioned to the jury. They weren't expecting him to testify on that or any other point. And so had the defense counsel's objection to the Gates testimony been sustained, defendant wouldn't be in the same position to talk about that at all. He may have still had it in his mind, but we don't know that.
If I interrupt, wasn't the thrust of the testimony from your client to explain the statements he had made when he was incarcerated, so that the jury would understand what context for those that was far less prejudicial than what the Commonwealth, how the Commonwealth had framed that evidence?
I think that was the reason offered by counsel for the defendant wanting to testify. When it was raised on the motions in limine, and the judge said, well, even though it's the defendant, it still has to be relevant. What's the relevance of this? And defense counsel said, well, there's some statements the Commonwealth's going to introduce to the effect that I'm a different person. Mm-hmm. And that he would explain that he'd come to terms with his sexual orientation.
So it was definitely relevant for that, no?
Well, it could have been, but I'm saying that had defense counsel's objection been sustained during the Commonwealth's case, we don't know what would have happened. Defendant may still have said, I want to testify, which his counsel couldn't prevent. And he may well have gone into his sexual orientation. Again, a thing counsel couldn't have prevented him from doing. But counsel did object at the first mention of it. And I think
what I hear you're saying is that in this situation, the prosecutor, even though the prosecutor knew what was likely to come, because defense counsel was quite forthright prior to impaneling the jury as to what he anticipated, the Commonwealth still had to wait until such time as the defendant testified, and that was brought up to then put on any evidence with respect to that?
Yes, I do. And in fact, in the Commonwealth's brief, it says that no such evidence was introduced in the Commonwealth's case in chief, but it was. When that was elicited from Gates that he had trouble, and clearly the relevance the judge saw at that time was the implication that a homosexual would have tendencies toward pedophilia or attraction to young boys. So yes, I think absolutely the Commonwealth needed to wait.
Attorney Redgate, even if we accept that that's true, where's the prejudice here?
Well, all the prejudice that would flow from that, I think, was pointed out in the strongest terms by the judge on the motion for motions in limine, that there's a tendency of people to associate homosexuality with all sorts of deviant sex, including pedophilia.
But your client testified to the fact that he identified as a gay man. So how does that?
Later, but I think the legitimacy of the objection and the ruling of the court has to be judged at the time it was made. Once it was made and it was evidence in the case, that could certainly change the defense counsel's position and ultimately his client's position on whether he would testify and what he would say. Once
is
that
there
evidence,
anything in our rec? Oh, sorry, I didn't mean to interrupt you. I apologize.
Well, that's all right. I just meant to say that the objection in the court's ruling needs to be judged in the context in which those rulings were made. They were made at a time when there'd been no mention of this before the jury, when the judge had said this is not relevant and it's highly prejudicial. When defense counsel objects, and the judge then says for the first time, surprisingly, oh, it's very relevant. And the reason she gave was that if he's not aroused by his fiance, that's some indication that he's attracted to young boys.
An argument that was never directly made to the jury. Right?
No, nobody made that argument to the jury. But I think the judge was quite correct to say that this is, a lot of people hold such ideas. And she said probably that this was not a well-founded idea, but she acknowledged that a lot of people hold this and that there's potential
Well,
for.
why would the rational inference just be that your client preferred to be with men, exactly as he said so, as he said later on? Why does it necessarily have to draw the inference that instead of other men, it would be that would be someone as young as 6 or 9 years old?
That inference is far from necessary. The point is that many people hold such a prejudice and would draw it, and we don't know which ones would. That it's highly improper, it's irrelevant, and it's prejudicial. Could be prejudicial. Maybe we have 12 jurors who would never think such a thing. We don't know. But the judge was right to point out that a lot of people would, and that introducing, even at the time when counsel suggested his client was going to say this, the judge said, hey, if your client wants to walk himself into this buzzsaw, so be it. But she still didn't think it was a good idea. Well, and she was only persuaded of the relevance, I think, by counsel saying, well, he's going to try and explain the statement that he made that he was a different person by means of that.
Well, it seems as if the judge was assuming at that point in the case, at sidebar, when the objection to Don Gates's testimony was made, that your client was going to go ahead and walk himself into that buzzsaw, as she put it. And what you're saying now is that that wasn't a fair assumption because he hadn't committed to testifying yet. And indeed, counsel couldn't commit him to testifying yet, let alone testifying in any particular way. But that objection wasn't made to the judge at the time. In other words, trial counsel didn't say, hey, wait a minute, judge, if you're assuming that he's necessarily going to take the stand and say he identifies as a gay man, he hasn't made that decision yet. So when judging the relevance of Don Gates's answer to this question, don't assume that my client's going to testify that he identifies as gay. That wasn't objected to.
I don't think he should need to approach that subject, Judge. He made his objection on the grounds of relevance. He was correct. It wasn't relevant, and it was highly prejudicial. The ruling was an erroneous ruling.
Well, the judge could have certainly not abused the discretion by determining that it was relevant when at that point in time, as Justice Sachs is pointing out, the information or the representation was that this information was going to be presented to the jury. And I have to say that when you look at the case as a whole, the evidence of your client's departure from Massachusetts and what happened, and then his combined with his statement that was recorded, it was a good explanation that he had. It was a good explanation he had for the jury to understand what he was trying to present, his point of view.
Honestly, I think those things may be correct, but that they don't bear on the question of whether the ruling was correct. The judge, more than anyone.
Well, I guess my point is that it was not unusual for everyone to anticipate that he was going to present that evidence because it did make a good deal of sense.
It may well have been in the judge's mind, but she better than anyone should have known that the defendant is not committed to testifying. No mention of it's been made in front of the jury. She must have noticed defense counsel refrained from promising the jury any testimony from the defendant. So I think the ruling was wrong. And the only other point that really seemed important to me to mention was this first complaint testimony. Now, I see the time is very limited now, but I'll only say that I think both in my initial brief and more particularly in the reply brief, made the point that King does not say what the prosecutor said it says. If you read carefully that footnote 24 and look especially at the distinction of when the court refers to the first complaint witness and when it refers simply to the witness after it has discussed the possibility of a substitute witness. And so I suggest that it's only if no witness to the disclosure is available that you can have this one-sided presentation.
What would be the benefit of that rule?
Well, it would be to keep out evidence that ordinarily wouldn't be permitted. I mean, we have this new rule of corroboration just announced in 2006 in King. Before that, such testimony wouldn't have been permitted. And in fact, in King, the court...
Well, but I guess my question is, what purpose would be served by saying if the actual first person to whom the complainant made the complaint is deceased, then the court must go down the line to the next witness, the next witness, the next, until it can find one that is able to testify. Doesn't that actually bring in more evidence for the jury in that you would get both the complainant's version and the first complaint witness's version, whereas in this situation where the first complaint witness was deceased, you only had one version?
Well, you do, and it doesn't tend to corroborate the complainant. It's just his own version repeated in connection with a disclosure. And in this case, the prejudice, it flowed not only from the disclosure, but the Commonwealth also overstated King in saying you can go into the demeanor. What King said is the first complaint witness can describe the demeanor of the complainant at the disclosure. And the court cited another case contrasting where previously they had held you couldn't do that. But they never said that you could comment on the demeanor of the first complaint witness, as this witness did, and it was very effective. He said, my mother got upset, she was crying. The next 3 sentences the prosecutor asked all said she was crying, all quoted 3 times in a row. It was highly significant, it was very prejudicial, and it was not permitted by anything in King.
I mean, you're going to have to leave. You're going to have to leave it at that because your time is up. But thank you very much. And I can assure you that none of your arguments are waived except for the one that you have told us on in your argument that has been waived. So don't be concerned about that. So I'll now turn to Attorney Martino.
Good morning, Your Honors. May it please the court, Elizabeth Martino on behalf of the Commonwealth. With me is Alyssa Goldhaber, Assistant District Attorney Goldhaber, who was the trial prosecutor in this case. She was joining by live stream. And the Commonwealth is asking that the court affirm the defendant's convictions for 5 counts of rape of a child. And I would also like to start with the first issue, if I may, just to sort of reframe a little bit the conversation about the testimony that was admitted. The point of the prosecutor's question to Dawn Gates about the sexual issues in her relationship with the defendant, and I think the rational inference from her answer was that the defendant preferred children, not necessarily boy children. I mean, the victims in this case happened to be boys, but the prosecutor could have and would have asked the same question had the victims been little girls. The question was, were you having sexual problems with the defendant, or was the defendant having sexual problems in his relationship with you? And the inference, if the answer is yes, is that, well, that's because he prefers children, right? There was nothing introduced by the Commonwealth about the defendant's sexual orientation at all in the case in chief, and it was not argued in her closing. His sexuality was not an issue in the case from the Commonwealth's point of view. And so that question really had nothing to do with the defendant's sexual orientation at all. It's just that the victims happened to be boys. So the question was about, were there sexual problems in the relationship because you were attracted to children as opposed to your adult?
What's the relevance of the question and answer?
The relevance is it more likely that the defendant committed a rape of a child because he was having, did you have sexual problems with your adult partner? The answer is yes. Well, then the inference, the inference, which is reasonable under the circumstances here, is that that's because he was attracted to children. And it's relevant because that was the charge in the case, rape of a child.
Is that a reasonable inference, that if you're having difficulties becoming aroused with a partner of the opposite sex, that you are attracted to children?
Well, I think the importance is that it was an adult partner, right? And he was having, And
okay.
Right.
So if you're having difficulties getting aroused with a particular adult partner of the opposite sex, then it's a reasonable inference, permissible inference, that you're attracted to children?
Yes, under the circumstances here, yes. That was the point of the question.
Did the judge actually conduct an inquiry as to whether or not an inference like the one you just explained would be more prejudicial than probative?
No, I don't think so. I mean, I think that was just a basic question, sort of, okay, the defendant was having sexual problems with, his girlfriend, and he was coming around the house even when so this is also testimony that came out. The defendant continued coming back to the house after the relationship with Dawn Gates began to sour.
I'm trying to think, do you think it would have been proper for the prosecutor to have argued that inference to the jury that because somebody was having trouble a challenging intimate relationship with his partner, that means that he would have committed this crime because he wanted to have sexual relations with children?
I think that's a reasonable, yeah, I think that's a reasonable inference. The prosecutor didn't argue it here in her closing, but I think combined with other evidence, that would have been proper. I'm sorry?
I made a comment that perhaps it was wise for her to stay away from that in closing argument.
Right. Yeah. I mean, she didn't argue it. It wasn't the main thrust of the case. It was a question. I think it was a reasonable question. I think it's a reasonable inference when combined with other evidence that was introduced in this case, right? Which is that, you know, the defendant did commit rapes of these children, and also that the defendant continued to come around the apartment after his relationship with Dawn Gates began to sour. You know, he continued to come, and I think that was the thrust of the prosecutor's questioning. Your relationship began to sour. You weren't sexually attracted to one another anymore, and yet the defendant continued to come to the apartment. So I think that was really the thrust of the prosecutor's questioning. And again, the prosecutor did not introduce any evidence about the defendant's sexual orientation. If I could just sort of lay out a little bit of a timeline of how things happened.
Can I just back you up 1 second before you do that? The point that he was no longer in an intimate relationship or a romantic relationship with Dawn Gates could surely have been made, and leading to the inference that he was coming around to the apartment for some other reason, without making the point that there were sexual issues in their relationship, couldn't it?
It could, of course, but I still don't think it was improper that the question was asked. I don't think, in light of the other evidence that was also introduced at trial, that it was in any way prejudicial. But of course, you know, the argument could have been made without asking the question. But I don't think the question itself was prejudicial. The question itself also didn't, or the testimony that, you know, Dawn Gates gave, it didn't have anything to do with, you know, again, the defendant's sexual orientation. There was not this, you know, what everybody was concerned about in the motions in limine, as my brother points out, that the judge said, you know, perhaps there could be prejudicial, it could be prejudicial if there's this testimony about the defendant's sexual orientation introduced, and the Commonwealth said, okay, well then I won't introduce that evidence, right? And she didn't, the Commonwealth didn't. And so, you know, that was just stayed away from by the Commonwealth when the judge first brought up that she thought it would be prejudicial. You know, and really just a quick outline of sort of how that all came out was that, you know, when the defendant and prosecutor and judge were talking about motions in limine, they were talking about the jail calls, they were talking about that the defendant had a boyfriend, and then the judge said, well, are we going to talk about the defendant's sexual orientation? Everybody said, no, we're not, it's out, you know, nobody's going to bring it up. And then the next day, the defense counsel came back and said, I think my client's going to testify. I think he's going to testify about his changed sexual orientation. And then everybody agreed, well, let's put that jury voir dire question back in to screen out anybody who might have any bias based on that. And so that jury voir dire question was put back in, and the jurors were all asked whether they could be fair and impartial if there was evidence that the defendant was gay. And in fact, a few jurors were excused for cause on that issue. So the jury pool was screened on that issue for any potential bias. Are there any other questions, I'm sorry, on that issue?
Does it matter that that jury voir dire question was asked and some jurors were excluded? Should we consider that in deciding whether the jury might have drawn this inference from the fact that the defendant was having sexual issues with his then girlfriend, that he might be attracted to young boys? Is the jury that has been screened in the way that you've described more or less likely to draw that inference? And can we make any assumptions about that?
Well, I think so. I think my brother brought up, you know, well, there's many, you know, inferences, and even the judge said that people can make those inferences about, you know, homosexuality and pedophilia. And here the jury was screened on that issue. So I think, you know, everything really was done sort of properly here. You know, at first that evidence was going to be kept out. The judge said, I think that there may be a possible prejudice here. Let's all keep it out. Prosecutor said no problem, defense counsel said no problem. And then the next day when, defense counsel had spoken to his client said he was going to bring it up. They said, let's use the jury voir dire question to screen out anybody that may have any bias. Jurors were screened out, right? And then the prosecutor still didn't bring out any evidence about the defendant's sexuality during her case in chief, nothing. It wasn't until the defendant testified that it came out at all, and the prosecutor still, even though it was in the case, did not argue it in her closing in any way. She also did not bring up the sexual issues between John Gates and the defendant in her closing at all. And then I think I'll just turn, if I may, to the last issue. I won't talk about the juror or the closing argument unless there's any questions about that. I think just quickly, the closing argument was just a fair response by the prosecutor to a defense that the victims fabricated their story and asked the jury to assess the witnesses' demeanors. And then the final issue about first complaint. I think here, the victim testified to his side of the complaint, even though the Commonwealth did not introduce a first complaint or substitute first complaint witness. And that is squarely within an exception that is laid out in King. King says, if no first complaint or substitute witness testifies at trial, then the complainant may not testify to the facts or details of the complaint unless the witness to the complaint is dead. Right, it's exactly laid out as an exception here, and here
does King go so far as to say that then the victim in this case can describe the reaction of the person who was receiving the first complaint?
Yeah, I mean, I think that's just demeanor evidence, right? It's not. He didn't say what she said.
But how is her demeanor relevant to judging his credibility?
I don't actually know the answer to that. I do know that the answer is that, here, the witness to the complaint, NC's mother, was dead, right? And in part was dead almost in a forfeiture by wrongdoing. She died in a time that the defendant had absconded and was gone for 20 some odd years. So, had the defendant been brought to trial when he was first indicted for his crimes, she would have been there. And the Commonwealth could have, put her on in their case in chief, but she died while he had absconded. And so she was no longer available. And this is a circumstance that, the SJC considered squarely, that where the witness to the complaint is dead, then the complainant may testify to the details of the complaint.
Sorry to interrupt. What do you say to the defendant's reading of footnote 24 in King together with the text to mean that even where the actual first complaint witness is deceased, the Commonwealth still has to go down the line and exhaust the possibilities of any other complaint witnesses before the complainant's complaint to the deceased witness can be used as the first complaint?
Well, it doesn't say that. I mean, it's possible that, as years go on, this court may find that, but King certainly doesn't say that. King says, if no first complaint or substitute witness testifies at trial, then the complainant may not testify to the facts of the complaint unless the witness to the complaint is dead.
But that comes after the sentence in footnote 24, that otherwise sentence about testifying where the complaint witness is deceased comes after the sentence that talks about only if a first complaint witness or a substitute complaint witness, C supra, is produced at trial. So one could conceivably read footnote 24 as indicating that you only reach the point of allowing the report of a complaint to a now deceased witness if you've exhausted all the other available complaint witnesses.
Well, I would disagree respectfully, Your Honor, with that reading. And I think this case illustrates one of the reasons why, right? The substitute complaint witness here wouldn't make any sense. It was a, caseworker that was later on after the investigation had moved along, right? Here, NC DM told his mother, Rose McLaughlin, right? And then I think, I can't remember exactly who told who first, but then, you know, one of the mothers called the other mother, right? So that was sort of the sequence of events. So completely excising one of those mothers because she died, you know, while the defendant had absconded for 25 years, it just completely changes the timeline of the case.
So that
here.
other mother testified, correct?
Yes.
And did she or would she have been permitted to say, as a result of a conversation I had with the other victim's mother, without getting into the details of what we talked about, I then asked my son what happened and he disclosed to me. Wouldn't that have been a permissible way of making the logical link that you're saying was necessary for jury understanding without bringing in the first, the initial complainant's version of what he told his mother?
It's possible, but I think that, you know, the theory underlying why we allow in the complainant to testify to the details under King is apparent here, right? Because it sort of aligns with, it helps the credibility of the complainant, right? And here, just bringing in some other substitute witness that has nothing to do with this series of events wouldn't offer the same, you know, aid in the credibility of the child victim that it does here in keeping everything, you know, within the same timeline. And also I would note, sorry, quickly, because I see my time is expiring, that the judge did give a limiting instruction at the time that NC testified, so that this evidence was not, you know, admitted for its truth, but only as sort of first complaint evidence. And also that it was very limited. You know, basically the question was, did you give your mom basic facts? And NC said yes. So it was a limited testimony with a limiting instruction given after, and it was in keeping with the timeline of all the other evidence without some substitute witness that had nothing to do with the timeline here, and you know that the NC's mother was dead because of the defendant's disappearance for so many years.
All right, well, your time is up. I'm just going to check one moment with the panel to see if anyone has any follow-up questions. Don't see any. So thank you very much, Attorney Martino, for your argument. Thank you both. We'll take the case under advisement and get an answer back to you as soon as we can.
Thank you.
Thank you.
We are live.
Thank you very much. Okay, good morning and welcome to today's remote sitting of the appeals court. My name is Ariane Vuono. I'm joined today on this panel with Justice Peter Sachs and Justice Catherine Hand. Just two quick reminders before I call the case for oral argument, and that is the rules that apply to oral argument as if we were in the courtroom apply to arguments on this remote platform as well. So you each have 15 minutes to present your arguments and there is no rebuttal. And second, upon occasion, and I don't want to jinx it, so far this morning we haven't had any issues, but upon occasions we do have some technical difficulties. They generally get resolved very, very easily. So we ask you to be patient if that happens, and we will be patient with you as well. So with that, I'm going to call the case Commonwealth versus KAQUAN HURD 2019-1810. And Attorney DeMayo, you may begin your argument.
Thank you. Good morning, Your Honors. So we raised several issues in the appellate brief. I'm going to focus today on the first one, the voir dire, and the last one, the closing argument. And in between those, there's a bunch of little evidentiary type of arguments, which are pretty straightforward. I can answer the court's questions, of course, but I think I probably won't have time to get to them. So on the voir dire question, the issue here is, there's really two issues. Was this appropriate for Judge Fahey to use this question, which I'm calling a CSI effect question, which in its variation, there were variations of it, but it basically asked, would you be willing, or do you think the Commonwealth can prove its case beyond a reasonable doubt without forensic evidence? Sometimes she added in just the testimony. So one question is that okay under the Perez-Gray case in light of the amendments to the Superior Court Rule 6? And then if it is, was it nonetheless incorrectly implemented by Judge Fahey just because of the way she did it and because there was really no follow-up? So we would submit.
Well, would you agree the nature of the question would have been is permissible, just to ask in general if a juror could be fair and impartial if there was no such evidence presented? Would you agree with that? Or is it the actual way the question is framed, or the topic of the question that you?
I think it's the topic of the question. I mean, I would have the same. I was reminded of this just last week. I was reading a transcript on another case. It was an arson case. Also a he said, she said kind of case. And the defense lawyer kept trying to ask the veneer, well, how do you feel about convicting just based on the word of one person? And the judge kept saying, you got to cut that out. And I think he was right, because it's the same. It's really two sides of the same coin. If you're going into the substance of the kind of evidence you're going to hear, I don't think any party is entitled to hear any party is entitled to hear a preview of a juror's impression. Now, I know I have to say that in light of what the SJC said in Perez and Gray, but I think under Rule 6, Rule 6 precludes hypotheticals that are close specific to the facts of this case. So if you're trying to tailor your question to the kind of evidence, I don't think that's right. Certainly, everyone can be asked if they're going to impartially listen to all the evidence with an open mind, and if they will follow the judge's instructions. But none of these 11 people said they wouldn't do that, probably because they didn't quite understand what they were being asked.
I'm not seeing, I'm sorry to interrupt, but I'm not seeing how this question seeks to commit jurors to a result. It seems to me that the question is just excluding those jurors who commit to the opposite result. In other words, who say, if there's no forensic evidence, I will automatically and invariably vote not guilty.
Well,
what's wrong with excluding those jurors?
All right, so it's a question. All right, so but on Rule 6 also precludes questions about what evidence would cause a juror to find for the attorney's client or the party. I think that's what it is. It's asking, would you be willing to convict, notwithstanding the absence of a certain type of evidence, when you the lawyer know very well that the evidence that's about to come in meets that description. Now, if we're wrong about that, I still think that this was not done correctly. So to answer your question, Justice Sachs, it's not clear to me at all that this is just precluding people. It's not clear that these 11 people really understood what was being asked, except for maybe one of them. One guy said, I would definitely want physical evidence, but for the most part, the second person, juror on page 63 of transcript 1, she was asked the question. The answer was transcribed as no, question mark. And then the court said, thank you, I'm excusing you. It's a confusing question. What does it mean for the Commonwealth to prove its case without, what is its case? Is it this case? I mean, some cases. Well,
it said, the question said, will the Commonwealth ever be able to prove its case, which makes it even more general and not a hypothetical that is close or specific to the facts of the case, as Rule 6 prohibits.
Well, that depends on what its case is. So is its case a rape case, which the clerk had called? He had already described the case. If so, it's still I mean, the jurors don't know what rape. The man on the street, the popular imagination, I think, is a bit broader, is a bit narrower for what rape is. It's not. The legal definition of rape includes stuff that you might not. Yeah. But the jurors here might not have known.
But the question didn't say, do you believe the Commonwealth was ever able to prove a rape case beyond reasonable doubt without forensic evidence? It just said, do you believe the Commonwealth was ever able to prove its case beyond reasonable doubt? So it didn't even get the fact of the nature of the charge into the question.
Well, I don't know how the jury interpreted that. If they interpret it as just any case, then I also don't see how it makes sense. How could you have like a case? How could you have a case of like battery with serious bodily injury without without either a wound or a photo or an X-ray? I don't know. It's a bad question, I would submit. It doesn't make a lot of sense. The point of the question is not to really.
You don't think you could prove a battery case based on a victim's testimony?
A serious bodily injury that healed.
Serious bodily injury.
That healed, and there's no evidence. This is the problem with hypothetical questions. It's hard to imagine. And I certainly wouldn't say someone was impartial and biased because they were skeptical of that. And that's the whole point of this question, it seems to me, is to preclude these 11 people who were excluded were not excluded randomly.
So you're saying these 11 people, in your view, would have been more predisposed to put the Commonwealth to the test because there was no medical or scientific evidence? They would have been more predisposed to an acquittal.
Exactly. That is the argument. These are people that Mr. Hurd would have liked, at least a couple of them on his jury, to be in the jury room. It would have changed the dynamic. Certainly the Commonwealth was entitled to strike them with its peremptories, but it's not at all clear.
It did have a number of them left, correct? In this case, 6 or so, if I recall.
Well, if you include these people, it didn't. It exceeded them. But yes, if you don't include the 11 people, then yes, they could have used. They could have struck some.
Now we get to another issue, which is so we're looking at this question with some hindsight, right? And it was not the question itself was not objected to.
That's true.
And there was no objection to excusing any of these witnesses. Excuse me, potential jurors.
Yes.
So,
I mean, it's the argument here is because these people are of I'm arguing that these people are of a certain view, as you just said, Justice Vuono. They're at least I suggest would be very able to follow the court's instructions probably if this had been fleshed out a little more. As in the Perez case, it says very clearly there was follow-up and people backed off their initial answers, and it was a confusing question. This whole type of question is really very grudgingly approved of by the SJC in Gray and Perez. Those are murder cases, and they said we're not going to find a structural error here and throw out this conviction. But if you're going to use these, we're skeptical of the need for them, and they need to be done very carefully.
Does it matter that those cases were, what, 15 years ago? I'm sorry, Perez. Sorry, not
like 8 or 10 years ago. Yeah, 8 or 10 years ago.
2011.
Yeah, I tried to get the SJC to take this case directly because there hasn't been any follow-up, but they didn't want it. But so it doesn't matter that there was no objection. I mean, I'm arguing structural error because these people I'm arguing this is akin to the Witherspoon case where the Supreme Court said, well, if you throw out all the people who express some qualms about capital punishment, then you've stacked the jury. That's part of the community, those people.
But this wasn't just throwing out people who had qualms or who were skeptical of the jury's ability to accurately discern which witnesses were telling the truth. This only removed those jurors who rejected the jury's ability to do so and said, I don't care what the witnesses say, I need to see forensic proof.
Well, if she had followed up and they had actually said, I don't care what any witness says, I'm never going to convict, then but I don't know. If you hear this question, the answer is no, and the court says, thank you, I'm excusing you. I'd submit that's not good enough. That's not what the SJC had in mind in Perez and Gray when they said to use this judiciously and sparingly. And so if we're wrong about structural error, then it's miscarriage of justice, which is of course always a tougher argument to make. This would be the case I would submit. This was a weak case. It was had to be ended in a hung jury. It all turned on the testimony of TB, who had some problems. It wasn't really corroborated by anyone. I mean, the parents corroborated that Mr. Hurd was in the apartment. He didn't make any incriminating statements. There was no consciousness of guilt. So if there was a case where this could make a difference, this would be the case, and you kind of have a control because you have the first trial where this question wasn't asked. And also
well, actually, a different question was asked in the first trial. And that was if you do not hear any DNA or scientific evidence in this case, would that affect your ability to be fair and impartial? I don't know why that question got changed to the extent that it did by the second trial.
Yeah, I don't like that one's a little clearer, but I don't particularly like that one because I think the question you're trying to ask is, will you listen to all the evidence before you form an opinion? And I don't know what that means because, well, I guess there's no point wasting time on that particular question since it wasn't asked at the second trial, but it seems to me
Right,
you
no,
look
it's
at
true,
evidence
but
holistic.
I'm just, well, I mean, the point of this individual voir dire is to, you know, is to try and ferret out jurors that are going to be receptive to your case on both sides, right?
I agree, but it's for the same reason that in that example I gave about the defense lawyer who I was reading about, who wanted to know, how do you feel about convicting people just based on one person's word? I think I agree with the judge. He shouldn't have been able to ask that, and I think the obverse of that is the Commonwealth shouldn't hear, and it probably goes through for civil parties as well. It's not really. I think that's the whole point of Rule 6 is to keep it very general. And this
I don't want to. I've asked you a lot of questions about that jury question, and I don't mean to cut you off on it. But was there any other issues you wanted to touch upon before your time is up?
The closing argument was another issue, and so the issue here was, well, there are a few issues, but one of it was vouching. So the prosecutor began by saying about TB, she didn't shy away when she didn't know an answer. She was honest and she admitted it. And if she just stopped there, that's fine. She's saying she was honest as to her bad memory, but then she continued on, and then it's a fairly short argument. I mean, it's about a 12-page argument, and it just contains a serial.
So I think what you zeroed in on was the fact that that prosecutor did say, you know, what motive did she have to come in and testify, right? Is that were the lines that you?
Well, that's part of. I mean, that's part of it. I mean, it's fair to say she didn't have any motive. Saying she came in and got up on that stand isn't great because there's cases saying. But my real issue is, she wasn't trying to hide anything. She wasn't trying to make things up or say something she didn't know about. She was honest. She's telling you what she remembers to the best of her ability, and she's not making things up to make them up. And ladies and gentlemen, the victim also told you about a time the defendant spread her legs and touched her, and she told you honestly that she'd forgotten about that. And in this case, the victim wasn't, again, not trying to hide anything. And she doesn't have a motive to lie, and she got up there and was honest on that stand. It's not just one comment. It's serious. This was not just a slip of the tongue or a heat of the moment kind of thing. This was just a bad argument, we would suggest. And it's not. You can compare it to the argument. The first case wasn't. The first trial wasn't flawless, but it was much more orthodox. It was, you saw her, and we'd ask you find her credible, and
we're going to review these challenges to the closing argument under a substantial risk of miscarriage of justice, right?
That's true. There was not an objection. There was not an objection, and therefore there was no curative instruction other than just the general one. And it didn't actually stop there. But we also take issue with some of the facts that they're sort of psychologizing about. TB doesn't want to be thinking about these things every day. She's trying to push it out of her mind. TB didn't say anything even remotely like that. So we argue that's not really a fair inference from anything.
Isn't that asking the jury to apply their own experience? Yes, Dr. Block didn't testify to it, but isn't that something that jurors can apply?
I don't think so at all. It's asking them to infer two things. First, that TB actually did this when she never said it. And second, that it's possible. It's not at all clear to me that you can will yourself to forget a bad event. And if it is possible, you'd need an expert on it. And as you just said, Dr. Block didn't go there. So, and then there was other tests, sort of psychological type of testimony about people. If people give a consistent story, they're actually not, that's not to be believed because that's not how memory works. There was just a lot of, Dr. Block and the experts are sort of an issue in their own, but the Commonwealth's argument was that the testimony wasn't that relevant. So there was no, how can there be prejudice if it's not relevant? But the harm came at the end when it was sort of mixed in with this closing argument, which was problematic in many ways, I would suggest. So those are the two issues, and we would ask that Mr. Hurd get a new trial. Thank you.
Okay, thank you very much. And just before you conclude, I'm going to double check with the panel to see if they have any follow-up questions, and they do not. So thank you for your argument. And now we'll turn to Attorney Sherman.
Good morning, and may it please the court. Catherine Sherman on behalf of the Commonwealth, asking this court to affirm the defendant's conviction for aggravated rape of a child and his 3 convictions for indecent assault and battery on a child under 14. I'm joined today by the trial prosecutor via the live stream, Assistant District Attorney Laura Montgomery. Beginning with the jury question, Justice Sachs, I believe you summed it up perfectly in terms of the purpose of this question and what it did. to assess whether or not jurors could be fair and impartial. This question was proper. The judge did not abuse her discretion in asking it. And as the court has noted, defense counsel neither objected to the question being asked, did not object to any of the jurors being dismissed.
Let me
and
ask you a question. Isn't it problematic here that, in fact, the prosecutor here did not ask whether or not the jurors could be fair and impartial in connection with the presentation of scientific or forensic evidence? The question was, do you think the Commonwealth can prove its case beyond a reasonable doubt without medical or scientific evidence? As I indicated, that the question in the first trial, which is a hung trial, which doesn't have any bearing on this, the question was more broad, if we can put it that way. But here is specifically is asking, do you think we can prove our case if we don't give this to you? We don't have this in our case. We don't have any scientific or physical evidence. Will you still be able to find the defendant guilty beyond a reasonable doubt? Isn't that what this is kind of the question is really getting at?
The question isn't problematic the way that it was phrased here, though it's different from the first trial. The second trial and the trial that's before the court, the judge really went to pains to have this question be aligned with the wording in Perez and the wording in Gray. I think she was making an active effort to do so, including the double negative formation that is in Perez that they started with when they began asking this question. So I actually think the way that the question was asked here is more in conformity with what has been approved by the SJC rather than how a layperson might understand the question. It's the question, the way that it was posed to the jurors was and did find out from the jurors whether or not they would follow the law in terms of deciding the case based only on the evidence before them. As the court has pointed out, the jurors who were dismissed based on the answer to this question were saying that they would essentially have a verdict in their minds based on whether or not one piece of evidence did or did not come in. And for that reason, this question was proper and those jurors were properly dismissed. I'll turn next to the expert witnesses in this case. These two experts educated the jury on aspects of child sexual assault that were beyond the knowledge of the average juror, and neither of them vouched for the victim. Neither expert had information about the facts of this case, the allegations made by this victim, and they made that abundantly clear to the jury, in that way differentiating them from any of the cases and the errors pointed to by the defendant in the context of an expert witness.
Can I ask a question about Dr. Block's testimony? Was the testimony about encoding that was elicited from Dr. Block intended to provide an explanation for why the victim may or may not have remembered all of the events that took place across the 2-week period, or why she may or may not have remembered certain details of a given event, or both?
I believe both, Your Honor. That brief amount of testimony, I believe it was 2 or 3 questions, did just tell the jury the way that memories are formed and explain to them in scientific language why someone may or may not remember something, especially in the context of a traumatic event. And it did educate them to why a sexual assault victim may or may not remember a specific detail about what occurred.
Your brief at page 40 says it was, I think it says that some of that evidence was irrelevant because memory lapses weren't an issue.
Yes, ultimately this case, the defense and the full testimony of the victim, I believe the expert witnesses interrupted the victim's testimony on 1 or 2 different occasions. So if my memory is correct, when these experts were testifying, the victim's testimony wasn't fully in evidence, direct or cross or redirect. That ended up ultimately not being the defense or the issue in this case, though the victim did have memory lapses and there were things that she forgot when asked about on direct. When she was reminded on redirect of certain allegations she had made, she explained how she had forgotten them in the course of testifying. I believe her quote was, "I don't know why I forgot them, but I didn't I forgot them when I was being questioned, and she provided the details.
So on issues such as the color of the knife, or whether it was a kitchen knife or a pocket knife, was she ultimately consistent in her testimony, even though her parents seemed to have different memories of that?
Your Honor, I don't remember from her testimony if she described the knife in detail and if she was consistent about it. However, she was always consistent that she was threatened with the knife in the kitchen. If there are no further questions about the experts, I'll turn to the next issue. The evidence of changes to the victim's behavior and the victim's familial relationships were valid evidence to corroborate the victim's accusations, to dispel the defense theory that she was fabricating the accusations, and to support her lack of motive to lie. Next, the judge did not abuse her discretion in enforcing the doctrine of completeness when defense counsel attempted to impeach a blind witness with grand jury testimony, taking his statement out of context.
Does it matter that he was blind?
It matters in terms of the procedure that was used to confront him with the grand jury minutes. Whereas normally a witness would traditionally be able to read and review their statement before being asked if they did make that statement. This witness was asked in front of the jury whether or not he had made it without any of the context being provided to him. So the jury was being misled by the single phrase being presented to him, and he did not have the benefit of reviewing his further statement before being asked to adopt or to deny that statement.
Does that same rule apply where the prior testimony was made under oath to a grand jury or otherwise and is substantively admissible? It's not just a prior inconsistent statement. Does the witness
and Your Honor, do you,
yeah, does the witness have a right to see, the prior testimony on paper before being asked those questions?
I don't have the answer to that, but I think regardless, in this context, the doctrine of completeness was applicable and was properly applied because the jury was being misled by the out of context statement that he was being questioned with. And the judge, when enforcing that doctrine, properly limited the context presented to the jury for his statement to a relevant issue and kept it as succinct as possible. So she properly presented the jury with the evidence they needed to evaluate that statement, the prior statement. Next, I'll turn.
But that served as a vehicle for getting in some additional testimony that hadn't come in previously, that he said he would slice her throat.
The victim testified to a similar statement, saying, I don't recall the exact wording off the top of my head.
He put a pocket knife to my throat and told me not to tell anyone or he'd kill me.
And though the wording is different, I don't think that's a substantial difference in terms of the threat being made with a knife to her throat. Next, turning to the closing argument. In this case, the Assistant District Attorney properly advocated the Commonwealth's case, and all of her advocacy was rooted in the evidence. She did not vouch for this victim, unlike the cases where a prosecutor alludes to personal knowledge to support credibility. This prosecutor alluded only to facts and evidence and the demeanor of the victim as witnessed by the jury. When
the defendant's first argument about the closing, I think, is that it starts with this beginning of the closing, that there was an entire paragraph or two paragraphs about how much the the witness and the witness's family trusted the defendant and how he abused that trust. And your reply, I think, is that that was necessary to show how he had access to her. But wasn't that a paragraph or two laying it on a little thick to make, if the point was simply to say they trusted him so he had access to her, that could have been quite easily said. But this went on for some time and seemed to be an appeal to sympathy.
Your Honor, I'd argue that it wasn't an appeal of sympathy because that was those were very important facts put into evidence by multiple witnesses. It not only explains the access that the defendant had to the victim, but also explained her lack of motive to lie, which was related to the deteriorating family relationships that came from when she did disclose the rape and abuse, and the personal effect that that had on her and her family. As she explained, she was frightened by him. She had all these family connections related to him. And I think the Commonwealth's argument, explanation of those facts and advocacy related to those facts was entirely proper. I'd also like to point out that with the closing argument, there were no objections made by defense counsel. So as the court has alluded to, it's easy to look back on these in hindsight, but to remember that in the moment when this closing was being delivered, the defense attorney found nothing objectionable about it in the delivery of the closing argument.
What about the statement that the victim forgot details because she was trying to push painful memories out of her mind? Was there anything in her testimony that supported that?
Well, the victim testified to how she had forgotten things. She admitted that to the jury, and that was important later in the Commonwealth's closing argument. But as the court has pointed out, the prosecutor's argument on this topic was calling on the jurors' common sense and life experience to explain the omissions in her testimony and why that might happen with a child, and asking jurors to think of that in the context of traumatic events.
Notwithstanding the fact that there was no objection to the closing argument, can you really justify using the term honest, describing a witness in the case as honest, rather than talking about the witness's demeanor, the witness's manner of answering questions, et cetera, which showed a degree of credibility?
Though the use of that word is not ideal, the context in which the word was used is clearly asking the jury to assess the victim's credibility based on what they saw in the courtroom. If I may read the context of that closing argument to the court, in the first instance on transcript volume 5, page 119, the prosecutor says the victim was on the stand for 2 days. You had ample opportunity to observe how she acted, how she seemed, how she was able to answer questions from both myself and the defense attorney. She didn't shy away when she didn't know an answer. She was honest and she admitted to it. She said, I don't remember, or I don't know. She wasn't trying to hide anything. She wasn't trying to make things up or say something she didn't know about. She was honest. She admitted that there were things that she forgot. If she were trying to go after the defendant, why would she do that? And after that, the prosecutor transitioned into explaining how the victim's testimony provided all the elements of the crime. So the use of the phrase in that instance, and similarly in the next instance, or the other instances, was rooted in the evidence that of the victim's testimony, and also was only asking the jury to assess credibility based on what they saw in the courtroom. The prosecutor was never alluding to information that she had or information outside the evidence that the jury had to consider. Similarly, the next instance of the use of the word honest is in arguing that the victim did not have a motive to lie, saying that, countering defense counsel's argument that that's irrelevant, saying that it was, and saying that she doesn't have a motive to lie. She got up there and she was honest on the stand when she told you what she knew, what she remembered, what she forgot. And then the prosecutor transitioned into how a defense witness did have a motive to lie and contrasted that for the jury. The prosecutor supported all of her argument through the evidence, and that's apparent throughout the closing argument. Additionally, the judge extensively instructed the jury on credibility and how closing arguments are not evidence.
All right. I think you've covered everything, even though your time is up. I think you've covered all the issues, but I'm going to check with the panel to see whether or not they have any follow-up questions. And I see that they do not. I want to thank you both very much for your arguments. Thank you for appearing in this remote platform. We'll take the case under advisement and we'll get an answer back to you as soon as we possibly can. Okay.
We're live.
Okay, thank you very much. Good morning. I'm going to start by introducing the panel to you. My name is Ariane Vuono, and I'm joined today by Justice Peter Sachs and by Justice Catherine Hand. I see that you're both representing yourselves, so I'm just going to give you a couple of reminders with respect to oral argument. Each of you have 15 minutes to present your side of the argument, and there is no rebuttal. So in this case, the appellant is you, Ms. Bush, and so you'll be arguing first, followed by Mr. Miles. And again, as I said, there is no rebuttal, so you'll have to make all of your points that you want to make to us during your first 15 minutes. Next, I just want to tell you that upon occasion with this platform, we do have we have experienced some technical difficulties. We hope that we do not. We have been smooth sailing so far today. But if we do, we ask for you to be patient with us. We will be patient with you, and generally any difficulties get resolved fairly quickly. I also want to tell you both that we have read the entire records. We have read everything that you presented to us, that you provided to us. And so we're very familiar with the background of this case. So 15 minutes is not very much time. You might want to get right to your most important points, okay? So you're the appellant, Ms. Bush, and so you go first, all right?
Thank you. Good morning, Your Honors. May it please the court, my name is Laura Boyce and I'm representing myself. The divorce case on appeal was the subject of a 9-day trial. It has been the subject of a previous appeal. In the first appeal, the appeals court affirmed some of the trial court's rulings and remanded other issues to the trial court for further proceedings. My current appeal focuses on the issue of child support and whether the trial court erred when it reversed its earlier attribution of $250,000 of income to Mr. Miles for the purposes of calculating child support. The amount of $250,000 was based on the compensation he earned during the marriage and the testimony of a vocational expert. It was also the amount that Mr. Miles was guaranteed to earn in an employment contract covering his first year working for Baird, the money management firm where he worked during most of the pendency of the divorce. In the July 25th, 2019 judgment and findings of fact, the trial court responded to the appeals court's concern about the availability of positions for Mr. Miles earning compensation commensurate with his past levels. This was at least partly because Mr. Miles had lost his job 7 days before the end of the trial. The trial court's July 25th, 2019 ruling based the child support amount of $6,188 annually only on Mr. Miles' unemployment income of $36,400 per year. It did not include interest and dividends from Mr. Miles' investments and declined to attribute income to Mr. Miles based on either his earning potential or on the over $2.3 million in assets that he received in the divorce settlement. This ruling ignored the fact that Mr. Miles was employed at Baird for 3 years of the pendency of the divorce in a position that would have compensated him with at least $250,000 annually in salary and bonus if he had met his employer's expectations.
May I ask, yes, Ms. Bush, when this case was previously before our court, the panel remanded for the judge to make further findings about a fairly narrow issue. That is, whether the husband exercised reasonable efforts since his layoff to secure employment commensurate with his education. And it seems to me that the judge did that, and this court did not direct the judge to go back to a period before his layoff and look at whether he had been working sufficiently hard at that time or whether he had interest and dividend income from his assets that should have been counted in child support during that time, or whether he had made misrepresentations to the court that should affect the amount of child support. It seems like the remand was on a very narrow issue about reasonable efforts since his layoff, and that the judge did address that issue. Am I missing something?
No, I would agree with that. I think that it contradicted the trial court's findings about the husband being underemployed and misrepresenting his financial position, and it conflicts with the principles of the child support guidelines. But the remand was this very narrow issue. Yeah, so were those issues that were raised or could have been raised in the first appeal? It was not raised in this way. It was about the vocational experts' testimony in the first appeal. Right, but that was the husband's appeal. You didn't file a cross appeal of your own in the first case. I did not. Correct. And you didn't argue that
this remand on child support should look at issues like interest and dividend income, or whether the husband had made misrepresentations, or whether he had been working sufficiently hard to earn what he had the potential to earn at Bayer.
No, on the first appeal, I did not, honestly, because of the outcome of the trial court's judge had been satisfactory. And so.
Okay.
Should we move to the issues that Mr. Miles filed on?
Yes, I have a question about the life insurance issue in particular, unless there's something you want to say about that at the outset. I'll just let you know, my general question is, what exactly is the trial court's rationale for, or the judge's rationale for not including your interest in that life insurance policy in the marital estate for purposes of asset division? And why is her rationale fair?
So I think her rationale is that it is part of my parents' estate planning. And it is, as part of that, it was taken into account when Mr. Miles got a disproportionate percentage of the assets from the marital estate. And so she had taken all of that into consideration, assigned it the view that it's an expectancy. It's a life insurance policy that if one stops paying the premiums on, then it will cease to have much. It will, I guess there's some cash value connected with it, but you cannot get the $500,000 payout if the premiums do not continue to be paid until my father's death. And so I think that is the rationale. It was also a pre-existing asset before the marriage. The amounts paid towards the premiums were all reimbursed by my parents. It is essentially a part and parcel of their estate plan.
So if it's permissible to exclude the expectancy from the estate,
well, it was not excluded.
Yes,
it was
considered
an expectancy, and he was given a disproportionate percentage of the marital estate based on that.
Right. So, but at the time of the first decision, the judge was under the misimpression that this policy was not owned by you and your sister, but by your parents or by some other entity, perhaps a trust. I'm not sure. Once that misconception was corrected, though, why wouldn't that your share of the policy become another expectancy that should tilt the division of existing assets even further in the husband's favor?
Well, I don't think that it changed who owns it. I don't think it changed what it's meant for. It's meant to pay the taxes on the parents' estate, and whether it's in trust or not in trust, and how it was set up doesn't change how the judge looked at it and what will happen to the amounts upon the timing of my parents' demise.
But there's no binding provision in your parents' estate plan or the policy or otherwise that requires that the proceeds of the policy be used to pay estate taxes. Is that correct?
Not that I'm aware of.
Yeah, and it's uncertain whether there even will be any estate taxes, isn't it?
Yes, but also uncertain whether one will continue to pay the premiums and get the amount.
Though, is that within your and your sister's control, whether the premiums continue to be paid?
Yeah.
I mean, if your parents don't go on reimbursing you, or if your father doesn't go on reimbursing you, then you can pay the premiums yourself because you and your sister own the policy.
If I have the money. My financial situation is not what it used to be.
And did the judge, the husband argues on appeal that the judge was under the misconception that this policy was part of the one of a number of trusts that your parents created. Did the judge say that? And if so, is that correct? Is it held by a trust, or is it held in the names of you and your sister?
So it is not held by a trust. I do not think that the judge believed it was held by a trust.
Well, I've asked a lot of questions. I may have thrown you off, but
No,
please get
that's
back
fine.
to what you want to argue about that.
So in addition to the TIA CREF insurance policy, husband has made some other claims that other assets should be part of the marital split. And the second asset is a speculated insurance settlement from a car accident about which there's no evidence, testimony, or findings. The third is uncashed checks of alleged trust distributions. The judge affirmed that there were no trust distributions other than reimbursing for the life insurance payment. And these uncashed checks are from 2011 and they expire after approximately 6 months. The fourth asset category is many other alleged hidden assets. There were never any findings that I hid assets, and 2 additional assets that Mr. Miles alleged were hidden are a GE Interest Plus account properly reported on my financial statements and some physical assets. Both of these were the subject of contempt of court charges brought by Mr. Miles, and the judge found in my favor on both instances. The second of his 4 items is a request for the appeals court to reconsider his claim that I received $300,000 in advance distribution of assets, but this contradicts information in one of the filings he submitted as part of his supplemental record of appendix, where he wrote that I received $225,000 in advance distribution of assets.
Where is that in the supplemental record appendix, if you have the page site handy? Or if you know what part of his...
It was on the front page of one of the filings for a new trial, and it's cited in the brief.
Okay. So you're saying that he conceded in one of his filings in the trial court that you had received only one $75,000 distribution plus
so it was
$150 for another year?
Yes, $225,000 total. It's in his one of his filings as the amount, and it's in the brief where exactly that is.
Okay.
And
there are various calculations that the husband's brief on appeal includes about that seem to make it unclear how money appeared in a particular TD checking account, I think, that could conceivably support an inference that there was more than one distribution in 2014, I think.
so there was not more than one distribution, and at one point I moved money between 2 joint accounts because one was very difficult to pay bills out of, and he brought contempt of court charges, and the judge found in my favor on those. And then all of this about paying legal fees. I paid a lot of legal fees. He paid a lot of legal fees. There's no reason why specific legal fees would be pre-distributions of assets and others would not. I would view that as simply a bunch of detail that doesn't have anything to do with the actual issue. And then these items, which he numbered 4 and 5, both rely very heavily on documents that were filed that are not properly part of the court record. And I filed a motion to strike on September 19th, 2020. In there are affidavits created after trial from people who did not testify during any hearing related to the case, deposition transcripts not discussed or admitted as exhibits during trial, proposed findings submitted after the end of trial not discussed or admitted during the trial, and various emails not discussed or admitted as exhibits during the trial. And those sections seem to be some sort of request to reconsider witness testimony and make a new evaluation about very wide range of issues, many unrelated to the actual divorce.
Ms. Bush, I have a question. I
Yes.
wonder if you could clarify for me what precisely happened in front of the trial judge on remand. Did you make any requests of the trial judge to consider new testimony, have a new hearing, or anything of that nature?
We were asked to just submit documents. It was the view of my lawyer that the judge was not open to these, but we did not file something specifically asking for it.
Okay. You still have another minute, and so please feel free to sum up or tell us anything else that you want us to know about your case before your time is up.
Sure. So for all the reasons identified in my two briefs, I asked that the appeals court reinstate payment of $53,508 in annual child support so that the children can enjoy a standard of living similar to the one experienced during the marriage and obtain medical and psychological care required to manage their special needs. And I also asked that the appeals court uphold the trial court's decision regarding asset division. The judge acted properly under Chapter 208, Section 34, and took into consideration all relevant factors and accounted for all marital assets as well as any possible future inheritance.
May I ask just one final question?
Yes.
I'm sorry. Is there anything that is preventing you from going in and seeking a modification of the child support order if either the husband has obtained or does obtain new employment, or if the husband isn't complying with the judge's order from July of 2019 to give you the weekly reports on his employment search? Could you seek a contempt order for that as a way of making sure child support is adjusted appropriately, at least prospectively?
I could. Prospectively, yes.
Okay. Thank you.
I see no further questions from anyone else on the panel, so thank you very much for your argument. We'll turn now to Mr. Miles.
Okay. Thank you, Your Honors. At a time when the very idea of truth and objective reality are undermined at the highest level in the United States, it is critical that the truth be vigorously defended by the courts at the appeals court level, even if it is subverted at the probate court level. The issue of truth versus lies is critical to several of the issues in this case, particularly the non-child support issues, and objective evidence exposes most of the lies. For the child support amount, I'll be much briefer than I plan to be based on the questions. But basically, the issue is fairly simple. It depends primarily on the reasonable efforts, which the trial court found on remand that I did have reasonable efforts, and the evidence absolutely supported that. And then in addition, the secondary issue was the availability of jobs. There was no evidence of availability of jobs, and there were no findings of availability of jobs.
Now, the judge made that ruling based on just 1 week's time. Is that correct? Because you had become unemployed just for 1 week, right?
Correct, and that was what the appeals court asked her to do.
Okay.
Okay. On the issue of dividend and interest income, and again, I'll do this very briefly since we already touched about it. The wife had multiple opportunities to appeal this issue. They were not included in the first child support order. She did not appeal that. She did not have anything about it in her motion to amend. And she did not, she never raised this issue until this appeal, and she has already waived her right on this issue. So, and the information was entirely stale, which she referenced in her brief. But I'll keep that. And I think that my brief goes into a lot more details on these issues. But importantly, the trial court finding, this is what she uses as the crux of her argument, is the trial court's finding that I was underemployed at Baird. That was one of 10 false, absolutely false findings that was removed after remand. It was the old finding number 75, which is the record appendix of page 41 and page 172, is it being stricken in its entirety. The wife's income attribution argument relies almost exclusively on this deleted and false finding that was stricken in its entirety and was not supported by evidence. In addition, the trial court found that specifically that I was laid off from my Baird job because my group did not generate enough revenues. Record appendix page 170, which was not related to my work performance. And in fact, my entire team was later let go from Baird. And wife lied about this in her response brief. Now I'll jump to the TIAA CREF. We'll focus on, since there have already been several questions about it, I'll focus on some of the other issues that have not been discussed. And there are so many holes, discrepancies, and contradictions in wife's false narrative about this $500,000 TIAA CREF account that it is clearly erroneous. The truth of the matter is fairly straightforward. It is a $250,000 marital asset paid for with marital funds, and there were no reimbursements entirely separate.
Judge did find, didn't she, that those premium payments from marital funds had been fully reimbursed by the parents?
Well, one, that is clearly erroneous because that includes the trust distribution checks after 2011, which did not go into the marital estate. So that's just the math proves that to be absolutely false. Now, the judge did find that as a finding. The judge had over half of the judge's findings were false, many of which were verifiably false. And I showed in my motion to amend, specifically showed that 65 of the findings were verifiably false. I could have shown more, except that I had time constraints on, I only have 10 days to file a motion to amend, but I could have shown even more of them were false. But you are correct that the judge did have that finding. The judge also had the finding that Laura did not own that account. That was ridiculously false. There are few things clearer than who owns an account. Every evidence in the
that fact was later corrected, correct?
Yeah, it was corrected, but I told the judge 4 different times that it was false, and she doubled down on that false fact until the appeals court. So this just shows the judge's intention is not to find the truth. There are other agendas going on. Sorry, let me jump back to, okay, so importantly, wife admitted in her proposed judgment that this is a marital asset, that's supplemental record appendix, page 221, item number 30 or 32, just like she admitted that she co-owns the account. Hasse versus Hasse case law clearly says that all assets, however obtained, are subject to division. Nearly every assertion that Judge Ulrich says about this account in the new fact number 113 is false, often verifiably false. I take apart each one in the brief. The judge indicated that this $500,000 policy is in a trust, confusing it with 4 additional policies that are in trust, none of which have a $500,000 face value.
You know, I'm not sure that you draw a connection between a couple of separate findings. I think the second one might be finding of fact 140, if I'm remembering right. And you are making the assumption that the judge views the TIAA CREF policy as being held in a trust. I didn't see the judge explicitly concluding that. And what information there is about the policy, I think it was perhaps, was it the first page of the supplemental record appendix or the third? The various documents from TIAA CREF seem to show fairly clearly that the owners are the wife and her sister.
Absolutely. That's why that had never been.
So I don't see where the judge is concluding erroneously that the policies are owned by a trust.
Well, much of what the judge says in the new findings of fact number 113 doesn't make sense unless it's in the context of being within the trust.
Why is that?
Well, I go through it in the because she says that the payments were made as a fiduciary for the trust, which that policy has nothing to do with any trust whatsoever. But one of the critical things that I wanted to go over, though, is this whole false story about the premium reimbursement, which the facts clearly show that this is not true. And Laura Boyce's own testimony shows that that's not true. And a wife initially claimed that the supposed reimbursements for the policy premiums were in untraceable cash and household gifts, and explicitly said that she was not reimbursed by check. However, much later, she changed her story to falsely claim that the trust distribution checks were actually reimbursements. The new twist on the lie was much improved, as it gave a supposed reason for wife to solely keep both policy and the trust distribution checks. However, wife was caught red-handed in a web of lies to steal least portion of these assets. And there's no dispute that I did not receive any part of any trust distribution since 2011, which is part of, if you do the math, and I go through the math in my brief, there are major contradictions and discrepancies in the math, but that's unrefutable that I did not receive all the reimbursements, even if one felt that the trust distributions were indeed reimbursements, which they absolutely were not.
So when this case got back to the judge after the first appeal, the judge invited the parties to submit proposed findings of fact and proposed judgments. Yours are not in the record before us.
I would happily provide them. And they did address these issues.
What did they say?
Oh, I had pages and pages and pages.
Yes. What do they say about the life insurance issue and the particular arguments you're making?
Oh, basically the same thing that I'm saying right here, that there were not reimbursements. There were massive contradictions in the testimony of wife's husband, or sorry, wife's father and wife. And the math of the checks is pretty clear, and the checks are all in there. So if you just do the math, and I do the math for you in my brief, none of it adds up. And again, this is all because this was a concocted false narrative, lies to basically try to allow her to keep both the trust distributions, which she received throughout the marriage, as well. And there was no connection whatsoever in timing or amount between the trust distributions and the policy payments. And the policy payments in the first year of marriage was approximately $6,500. The trust checks never exceeded $4,000. Therefore, if you believe this concocted lie, then it would have taken like about probably 6 years to reimburse that first $6,500 in policy premiums, because each year the policy premium exceeded the checks. So the whole thing is just absurd. They're trying to connect two completely unrelated things. And quite frankly, they didn't do a very good job trying to concoct this web of lies. And the evidence is pretty straightforward that this is not true.
So if we assume for purposes of argument that there will be some estate taxes to pay, then even if there's no written language that binds the wife to use the life insurance proceeds to pay the estate taxes, those taxes are going to have to be paid out of some money, and dollars are basically fungible. So does it matter whether there's nothing binding the proceeds themselves to be used for an estate tax?
Well, they actually say that the intention of the funds, they don't even say whose intention it is, if it's wife's or father's or who knows.
But does that matter?
Well, I think legally it does, absolutely does matter. But what is very important is there are going to be $0 of estate taxes unless the inheritance is above $22 million.
That's a prediction now based on what the law will be at the time that an estate tax, if there is one, would be applied. But I want to get back to whether it matters, whether there's any binding requirement that the life insurance proceeds be used for estate tax.
Well, what matters is that this $500,000 policy is clearly a marital asset. That's, I think, what matters. The Hasse versus Hasse shows that that is indeed a marital asset. So I think that, and by the way, to your other question about how can they pay the estate taxes if there are any, and again, under current law, it has to be over $22 million. And they have $1.57 million across 4 other whole life insurance policies that are all within the trust that will pay out $1.57 million upon Laura's father's death. That will easily be able to pay the estate taxes.
So this is a $500,000 policy. The wife's share, should the benefit be paid, would be $250,000. What do you contend should be treated as a marital asset? And since you did get a greater share of the more certain marital assets as a result of the wife's expectancy of the estate, how do you contend that that should be adjusted further in light of the existence of the life insurance policy?
Well,
you were supposed to get, it was supposed to be something like 5248, 5347. I know you've made some arguments about whether those figures were actually realized in practice, but
Right.
does the existence of this expectancy mean that you should get 1% more of the marital estate, or 0.5% or 2%? What are you saying?
I think I should get 53% of this marital asset, the 250,000 that is owned by the marital estate. I want 53% of that. And again, the reason why I only got 50.6%, if you do the math, 50.6% of the marital assets, which was less than the premarital,
to answer Justice Sachs' question, what you are saying is 53% of $250,000.
Correct.
Okay. And what about the payment of the premiums?
I would be happy to contribute to the payment of the premiums until through the end of the policy. I would happily contribute.
Yeah. But what mechanism would the judge have of requiring that in the context of a divorce?
I don't know what mechanisms are available to the court, but certainly she could say that my receiving the 250,000 or my 53% of the 250,000 is contingent on my showing evidence of paying the premiums. Or again, what I would say is I would pay 53% of the wife's portion of the premium, because the other half of the premium is being paid by wife's sister. Or either that, or the simpler thing is we could do something where she just pays me the money up front. And then that gets rid of the time issue.
Yeah. I want to turn to the issue. We only have a very little time left, but the $75,000 advance, and the wife mentioned in her argument page in the supplemental record appendix that addresses this.
Yes.
What she may have been referring to was this, your motion to amend the judgment. I see the second page of it, which is supplemental record appendix 129, says the court's asset division, this is paragraph 4 if you have it in front of you. The court's asset division allocation only showed $150,000 in advance distributions to wife. However, wife was given at least $225,000 in advance distributions, as is documented in the court's procedural history items 20B and 37. So is that an acknowledgement that the advance was $225,000?
Absolutely not. And that was not the reference she had. And by the way, the text there says at least 225,000. And quite frankly, I didn't put the 300 to 350 because quite frankly, I had time constraints. I was rushing to get that motion to amend in. But the specific page that she references is page 197 in the supplemental record appendix. And I'll read the point that she says. So, mistakes seem to have been made on financial matters. The vast majority of the cash allocated to husband in item 28, 458,746 as of the 9/10/15 financial statements used in the judgment, were in the Ally Bank CD and the SFGI account that both had zero balances for many months. Most of this money, meaning the money from those two accounts, was used to fund wife's $225,000 in pre-distribution of assets and husband's $150,000 in pre-distribution of assets. This in no way says that the total amount of her pre-distribution was $225. It was just referring to the money from those two accounts were part of the $225. The others were taken from the Baird. So in no way do I concede that she only received $225. And quite frankly, more importantly than what I say, look at what the evidence says. She was given 2 authorizations, one in person. Just days later, she started withdrawing significant amounts of funds per the authorization.
Well, your time is actually up.
Thank
So I'm just going to see if the panel has any other questions for you. And I see they don't. And my final question is just to confirm a question that Justice asked of the wife, which is that you would agree that if there's been a change in your circumstances, a material change in your circumstances in terms of your employment, that would make a difference in the amount of child support that you would owe, and that wife could seek a modification on that basis.
That is correct. And I'm forced to report her weekly what jobs I apply to, and I have to report to her if I gain employment and all the terms.
Right, that was ordered by the judge on remand.
And I've complied fully to everything in the judgment.
Okay. All right. Well, I know the two of you have are difficult situation. You've both been in court many, many times. This has been in the appeals court twice already. All I can tell you is that we will read everything. We'll take the case under advisement and we'll do our best to get an answer back to you as soon as possible.
Thank you so much. And I greatly appreciate that you're reading the briefs in full and that you're looking at the evidence.
We are live.
Okay, thank you very much. And I was going to say, yes, it's still before noon, so good morning and welcome to today's remote sitting of the appeals court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono, and I'm joined today by Justice Peter Sachs and Justice Catherine Hand. Just two quick reminders before we begin, and that is, as you probably already know, that the rules of oral argument that would apply as if we were in the courtroom having argument apply to this remote platform as well. And second, if we have any technical difficulties, I'm sure we can work them out fairly quickly. We ask you to be patient with us and we'll be patient with you. We already know what the split at the time is between Attorney Frizzoli and Attorney McCarthy. So we're ready to start now with a full 15-minute argument by you, Attorney Kane. And please, everyone, remember that this case is impounded. We are streaming live to the public. And so we need to keep that in mind during the course of your argument, okay? Attorney Kane.
Thank you, Your Honor. May it please the court, my name is Nora Kane and I represent the appellant mother. I believe there are two questions before the court today. The first question is whether the sibling visitation statute includes siblings who are not part of the current docket number or case. Mother argues that they are part of that statute. In support of her argument, Mother points the court to the language of General Law, Chapter 119, Section 26BB. If you look at the language of the statute, there is no language requiring that the siblings be part of the same docket number.
May I just back up, Ms. Kane, for a second and make sure we know where we are procedurally? You have two appeals here. One is from the denial of your 60B6 motion. I didn't see any arguments in your brief pressing a claim that there was error in denial of the 60B6. Is that accurate?
I believe that that I did argue that the court made an error by not allowing Mother's motion for a new trial, which preserved this issue before the court.
Okay, and then your second, you're saying that preserved the issue of what 26B requires?
So Mother filed the motion for a stay and a motion for a new trial before the single justice, and that was denied. And then Mother appealed that.
Yes. Okay. So that's your other issue is whether this case should have been stayed to allow you to seek a new trial.
Yes, Your Honor.
But if we upheld that, then you could go back and seek the new trial.
Yes. Okay. So again, I was talking about General Law, Chapter 119, Section 26B, and the specific language in it. Again, nothing in the language requires that the siblings be part of the same docket number. Furthermore, if you look, the language discusses siblings being in various settings, such as with a parent, with relatives, in foster care, in pre-adoptive or adoptive homes. And the SJC looked at the issue of sibling visitation and care and protection of Jamison. That was a case in which there was a question whether a child in a guardianship would be protected under the statute because the statute does not specifically mention guardianships. And the SJC concluded that the statute was meant to protect siblings separated by state intervention, and that did include children in guardianships, because any other reading of the statute would frustrate the legislative intent.
Attorney Kane, what is your best case for the application of the statute in the way that you suggest under the circumstances we have here, where you have a number of siblings who are not part of the subject or the part of the action directly, and there's a question about whether and how to bring them in?
Yes, Your Honor. So there's no case specifically on point about siblings that are not part of the docket. The only case that touches upon it is a Rule 23 case called Adoption of Lark. And in that case, the court does mention that I believe the siblings are not part of the same case, but doesn't specifically address that issue. So I don't think that there is any case specifically on point saying whether siblings who are not part of the same docket number are protected under the statute. So my argument is not based on case law, it's based on a reading of the statute.
And in Lark, though, and I'm not sure how this plays into your argument, but if I'm not mistaken, there was an issue both of standing and potentially of waiver. How does that play in here?
So in regards to standing, there was the argument that mother doesn't have standing to ask for these visits, but she did because it wasn't raised specifically at the trial level. But the reason why it wasn't raised at the trial level was because mother was never advised of her right to raise the issue, which mother argues was ineffective assistance of counsel.
She was in this instance, mother was appointed counsel to represent her on the ineffective assistance of counsel motion, and it wasn't raised then either, was it?
Yeah, it wasn't. Mother had 3 attorneys in this case, and it wasn't raised once by any of them.
There was no ineffective assistance claim before us that relates to the attorney, nor am I suggesting necessarily that there should be, but there isn't one concerning the attorney who represented mother on her ineffective assistance claim in the trial court, correct?
Right. I did address that none of the specific attorneys representing mother raised it, that none of the 3 raised the issue.
Thank you.
And that everyone was aware that mother wanted her children placed with maternal grandmother where the siblings resided. So it was an issue people knew about, but no one, and mother submitted an affidavit saying that she was never advised of her right.
So just to be clear, the 60B6 motion did not make any argument about the sibling visitation issue.
The argument in the 60B6 was that trial counsel was ineffective because she never advised mother of her right to request both a competing plan, which has become a moot issue, and sibling visitation. And that is why mother was not able to raise the issue below, because she wasn't advised of her right. But even though mother didn't raise the issue below, my argument is that under the statute, either the court or DCF was required to address this issue. The statute doesn't say that the court or DCF are only required to address the issue if a parent raises it, or if a child raises it. They're required to address sibling visitation.
What if the situation where the court is not aware of other siblings?
So I addressed this in my brief. There were 6 reports filed with the court in this case from 3 months after removal all the way through to the trial. And in all 6 of those reports, these 3 additional siblings were mentioned.
No, I understand the situation in your case, but you're asking us to interpret the statute to require the court and the Department of Children and Families to do something. And I'm trying to figure out how that would actually work.
I'm sorry. The argument is that there's no indication that the court did consider this issue, and that when the court is presented with information regarding siblings, that the court, my argument under the statute is that the court is required to consider extended siblings. If you look at the federal—
Is that only if they're aware of them? Is that their point? Only if they're aware of them, or what?
Well, the argument is that under the Federal Fostering Connections to Success and Increasing Adoptions Act of 2008 and the ABA guidelines around those, that judges are supposed to be asking these questions at the inception of the case, not just in regards to the children that are listed on the docket, but whether they're, you can see from the questions that are recommended, does the child have siblings? Do we know where the siblings are? Are the siblings visiting? These are not questions you need to ask about children listed on a docket. You see them listed there. You see whether they're siblings. They're in DCF custody. We know where they are. And it's an easy question about whether they're visiting. I think that the ABA judicial guide is saying you need to ask these questions about additional siblings as well. And then
where the statute says the court or the department shall, whenever reasonable and practical, etc., it seems to say either the court or the department should do that, but by not making clear which one is supposed to do it, it seems to take some of the mandatory emphasis out of the statute.
Your Honor, I would argue if you look at adoption of Garrett, in that case, the court ruled that because DCF was addressing sibling visitation, that that the court didn't need to address the issue. So yes, if DCF is addressing the issue and providing visits, the court doesn't need to. But I would argue that when DCF has not addressed the issue, that the court needs to ensure that the issue is addressed.
Do you have a case that tells us that the court has a sua sponte obligation to do that versus, as in the ordinary course, being required to act when the issue is raised?
The argument is that under the statute that the court is required to ensure, just like many other issues that the court ensures. Like if you see in the record appendix, I attached the court orders, record appendix volume 1, 95 through 1 of things that the court went through to ensure were addressed, due process issues, service issues, paternity, interpreters, identification. My argument is that sibling visitation should be one of those questions that the court is required to ensure is addressed. If DCS is addressing it, then a remand isn't required. But if neither DCF or the court have, and actually if you look at, it's a case that was decided, adoption of Xander, and that was when the statute was written differently. This was the previous statute, which only said the court was required to address the issue. It did not say the court or DCF. And in adoption of Xander, there was a remand because the court didn't address the issue of sibling visitation. So I would argue under Xander and Garrett that, and actually another case, a Rule 23 adoption of Yves, that if neither the court or DCF has addressed the issue, then a remand is necessary.
Are those cases though talking about schedule? Just to remind me, I may be mistaken, but are they talking about the obligation to schedule visitation versus the obligation to address the requirement for it?
They're not required to schedule, ensure that visitation, if in the best interest of the children, is occurring. So it's always an analysis of, in each case, would it be in the best interest to have visits? My argument is that the court must at least explore the issue, see if visits are in the best interest, and if they are, to order them.
So I want to come back to best interest in a minute, but can I take you back just for 1 minute to the issue about the 60B6? Can you show me where in the record the issue of the ineffective assistance on the sibling, where the issue of the sibling visitation was raised in the 60B6 motion?
I don't have the site. I know that I discussed it in my brief, and I can certainly get a letter to the court with the specific site to it. I don't have it off the top of my head. You mean in the motion that was filed with the stay?
No, I'm talking about the motion that was filed in the trial court.
I wasn't able to file the motion in the trial court because I wasn't granted the stay. This was filed after docketing of the appeal, so I filed the motion for a stay with an attached proposed motion for new trial, and that's in the record.
Sorry, go ahead. Okay, thank you.
So I see that I only have a few minutes left.
I'm sorry, Ms. Kane, just so we know, we'll make sure we're all on the same page here. The motion, the 60B6 motion that was filed by prior counsel in the trial court, which is at Record Appendix 148, does not seem to me to raise any issue with respect to sibling visitation. So although you've appealed that in your notice of appeal, I don't see any arguments that you're making that that the denial of that motion was error, other than perhaps that the court had an obligation sua sponte. But even that argument was not made in the 60B6.
So I'm sorry, Your Honor, I was confused. So there was a motion for a new trial filed in the trial court by then trial counsel.
Right. I'm not talking about a motion for new trial, just to be clear. This is a motion for relief from judgment.
Right, right. Then I filed a separate motion for stay and motion for new trial based on ineffective assistance of counsel. So
and that was in the single justice session here.
Yes, yes.
Okay.
So just in regards to the second question before the court, if the court does agree that siblings who are not part of the current docket are included in the protection of the statute, my argument is that it's an error of law if neither the trial judge or DCF addresses the issue. And I think that we already talked about a lot of this. I don't think that the issue was missed.
Can I ask you?
Oh, sure.
I didn't interrupt you, but your time is up. how would you go about applying then the best interests of the child standard here, when you're talking about some children who are not the subject matter of the petition? Are you looking only at the best interests of the children who are the subject of the petition, that it would be the best interest of those children to have sibling visitation? Or now you're also requiring the judge to consider the best interests of these other children, whomever they may be, and how many there may be? How does that work?
So I would argue, yes, Your Honor. I would argue that, yes, the court would have to consider the best interest of all the children, and there may be different orders depending on different children. And I think that was addressed in Care and Protection of Jamison. I think there was some discussion in that case about what was in the best interest of the children. One child was in a guardianship, and some other children, I believe, were.
But they were all those children were the subject of that petition.
They were initially, yes, but my argument was that the court didn't say we're saying that this child is subject to it because this child was once part of the same docket. That's not what the court said. That was a fact in the case, but that wasn't the reasoning. The court said any children separated via state intervention were protected under the sibling visitation statute. So the trial judge really is the best person to look at all the factors. The trial judge knows all the children in this case. The children with the grandmother were placed through the same court by the department. She really would be in the best situation to weigh the best interest of all the children and to take evidence on the issue. There never was any evidence presented to the court on the issue. So the trial judge really would be in the best situation to do that.
Okay.
And I see I'm out of time, so
time is up.
Okay, thank you.
Okay, thank you very much. Nothing that you have said in your brief is waived, obviously, if you didn't get a chance to talk about an oral argument. So you need not be concerned. I'm going to move now to Attorney Presiding, who has 10 minutes to argue for the department.
Thank you, Your Honor. May it please the court. Oh, am I on? Okay. May it please the court, my name is Carol Frizzoli and I represent the Department of Children and Families. The trial court decision in this case in not ordering sibling visitation over siblings who were not subject to the personal jurisdiction of this court was correct. There was no error in this case. Now, with respect to 11926B of the sibling visitation statute, what my sister would contend is that the department and the court would have to issue sibling visitation orders over parties who they had no personal jurisdiction over. In this case, the grandmother was never part of this case. Clearly, the court was aware of grandmother as well as the department. They're mentioned in the adoption plans for the children. But in this particular case, the grandmother was not, there was no visitation with these siblings. There was no established sibling relationship. At no time did this sibling group ever all live together. And in fact, the court, when the court issued the original termination of parental rights stipulation for judgment in this case, a sibling visitation order was issued because at that point, the two sibling groups, which are two sets of twins, they were supposed to be placed in two separate homes. So the judge clearly considered the sibling visitation statute as well as all the parties and their attorneys, and they came up with a sibling visitation order which provided for 4 visits a year between these two sibling groups. So therefore, it's the department's, so I think what my sister would be arguing is that the court should have gone and issued another order over the grandmother and these other 3 siblings without having any personal jurisdiction over these parties. And again, in Jamison, which my sister cites to, again, in that case, what's key in that case is the child who was in the guardianship is the person who petitioned the court. So the children in this case, the 3 siblings of the grandmother could always petition this court to get sibling visitation. But again, they are not, in this particular case, they're not parties. They're not subject to the personal jurisdiction of the juvenile court that was deciding this case. So in addition to not having personal jurisdiction, 119.26b, and as more spelled out in Jameson, talks about state intervention, that children separated by state intervention. In that case, very often the same care and protection case, or the same, if they were placed in various foster homes, because the purpose of the sibling visitation statute is to make sure that you ensure that even if these children cannot be placed together, at least they can establish their relationships amongst each other.
To anticipate where you're going, the fact that the children were taken from the mother in two separate proceedings here doesn't change the fact that if the proceedings had never been brought, they would all be living with the mother and therefore with each other, wouldn't it?
Yes, Your Honor. But again, then we get back to, we're not disputing that these children were all state, but we're saying that where there's two sibling groups in this case, so that 119 section 26 doesn't require the court or the department to ensure that there's sibling visitation where the court again doesn't have personal jurisdiction over these other siblings. But again, Jameson talks about, state separate interaction, separation. This is not that case. And in fact, that's the reason for that is we get back to that best interest standard, because Jameson's very clear that we have to show that it's in the best interest of these siblings to have a relationship with each other. If in the case where these children are not part of the case, how do you show it's in all of these children's best interest to have a sibling order, a sibling
relationship? Could they be
relationship?
joined as necessary parties under Rule 19?
They certainly can, but again, it's the children have that right to petition. That's not what we have in this case. In this case, the grandmother's three children never petitioned this court for sibling visitation.
Okay. What about could the mother during the trial, or before a trial occurs that terminates her rights, seek to vindicate the rights of the children at issue in that particular case by moving to join the other children as necessary parties, and then moving the court to make an order for sibling visitation, even if her rights are terminated?
Well, I don't think mother would have standing to do that.
Not even before her own rights are terminated?
I'm thinking procedurally, I don't know how mother would bring, because the Department of Children and Families is the petitioner in that case. So they are a party, but I don't see a mother being able to bring in, non-named parties to the case, because I just don't see procedurally how it would be done in juvenile court.
Well, a defendant can bring in can file a motion under Rule 19 as well as a plaintiff.
Again, I'm not saying that it's not an option, but again, it would be something the juvenile judge would have to consider. Very often in the juvenile court, they see grandparents petition or guardians try to petition, and it's up to the juvenile judge to decide, whether they should have party status. So it's up to that juvenile judge. So again, I don't know if there's anything, preventing that from happening. I think it would have to be a motion that the juvenile judge would have to decide whether they can be substituted as a party in the case. But again, in this case, which is very telling, is this issue of sibling visitation was never raised. And I think your honors noted that the first notice of appeal on the 60B was just on the case of mother's rights. Mother at the time had objected to the stipulation for, she had entered into a stipulation for her termination of parental rights. 3 days later, she objected to that. And there was a 2-day hearing on whether, mother had voluntarily entered into that agreement. That's what was appealed under the 60B. There was no reference to any kind of sibling visitation or even placement issues at that point. It wasn't until the appeal was docketed 9 months later that the issue of this sibling visitation came up. And that was done basically after, with the motion to the single justice that it was ineffective assistance of counsel. So in addition to the court not having personal jurisdiction over this, and there was no evidence, no best interest evidence established here, what is also telling is that mother does not have standing in this case. The adoption of Malik is very clear that when a parental rights are terminated, they do not have rights, and mother has an appeal determination. She doesn't have rights to argue about sibling visitation. So it's our position that there is no standing in this case to even present this issue. And furthermore, Your Honor, I would point out that with respect to ineffective assistance of counsel, again, this actual issue was actually litigated in the lower court. And just it's the standard of ineffective is not met because clearly these attorneys, the three different attorneys, in fact, I think the judge determined a factual finding saying that the attorney was conduct was impeachable in this, unimpeachable, I think.
Just to be clear, the issue of whether counsel was ineffective by not raising sibling visitation has not been litigated yet.
Again, it was raised though, because there is a sibling visitation order.
No, I'm talking about this the visitation between the 4 subject children and the 3 other children, whether counsel was ineffective for not seeking such visitation on behalf of the mother has not been litigated. Is that correct?
That has not been litigated. No, but again, because it wasn't an issue in the case, mother had never raised it. So finally, I would tell the court that although I'm bound to the record, there is certain circumstances in this case that have changed. But again, I'm bound to the record, so I will relate that. I will close with that and rest on my brief.
Okay, I see that your time has expired, and thank you very much. We'll now turn to Mr. Attorney McCarthy on behalf of the children.
Thank you. Good morning, good afternoon, justices, and good afternoon, counsel. Mother lost 7 children due to unfitness, and now she's attempting to place blame on her second trial counsel, the juvenile court, and a single justice of this court. And she's asking this court to adopt her narrative on sibling visitation. The children don't adopt that narrative. And to be clear, the children are not asking for sibling visitation at this time. Their only desire is to achieve permanence through adoption. Mother's narrative only seeks to hinder and distract from the children of attaining that goal they have for themselves. And it's not helpful for the children to attain permanence. Mother's narrative isn't helping them achieve that goal. For the children, this case is not about the interests of the grandmother, the interests of the non-party siblings, the interests in children in general. It's personal to them, and it is, it's just about them achieving permanence, stability, and in the home that they love, and that's what they're looking for. This decision of the single justice, the children would like to point out, can only be reversed if this court finds that the single justice abused her discretion or committed an error of law. The mother is tasked with showing this court at least some information that would tend to show that the single justice did abuse her discretion, but mother only merely points to the information that she submitted to the single justice, and that information that she submitted to the single justice, for instance, her affidavit and the mother's affidavit and the grandmother's affidavit, would be removed from consideration if this court found that the single justice did not abuse her discretion. This is not a review de novo of the single justice's decision. It's if this panel, the children would suggest that if this panel finds that the single justice did not abuse her discretion, then the decision, the the children, there remains nothing else to be decided after that point. The single justice didn't abuse their discretion. Mother is left with no information to present to this panel, and the case is decided. As far as termination, in addition, like my sister said, mother's rights were terminated, which means she didn't dispute this termination before this panel. Because mother's rights were terminated, she has no right to any say regarding the children. And that would include if hypothetically this case was remanded to the juvenile court. Mother doesn't have any say in the juvenile court. She's out of the game once its parental rights are terminated. She has no say regarding the children at this point. Her parental rights are terminated. She doesn't have any right to input to any decision made regarding the children, including sibling visitation. Childhood is fleeting and the children are waiting for permanence. And sometimes it's only fair to say enough is enough, and the children are saying that in this case. The children have been in DCF custody since March of 2018. That's just about 3 years. And time is passing quickly, and they don't want the delays associated with a return of this case to the juvenile court for any reason. So therefore, the children would ask that mother's appeal be dismissed and that the decision of the trial court be affirmed in all respects. And we would thank you with that, and we would rest on our brief.
Counsel, I'd like to just refer back to something that DCF counsel said at the end of her argument, and say, at least speaking for myself, that I appreciate counsel's determination to confine herself to the record, and that's entirely appropriate. I'm assuming that if this case were moot somehow, or if one of the issues in the case were moot, that would have been called to the panel's attention, or that if the parties can consult on that, and if there's an agreement that an issue is moot, you would let us know that, or at least seek leave to file something letting us know that.
Yes, Justice Sachs, and I think what my sister did say is a serious matter, and I think really the obligation is on the appellate attorney for the mother to bring this information before the court.
Well, we won't make any assumptions, I think, on what that information is, and we'll proceed on the record that we have unless we're informed that something has been mooted out.
Your Honor, I'm not aware of any issues that have mooted, any issues that have become moot. The only moot issue was the one I mentioned, the competing plans that the children are together and that is no longer an issue. But I'm not aware of anything else becoming moot.
All right, well, we'll take that answer, even though it's a little bit out of order, and thank all three of you for your arguments. These cases are always very difficult, as we know, and we appreciate your careful review of all the issues and your briefs in your case. We'll take it under advisement, and we'll again answer back to you as soon as we possibly can, okay? Thank you very much.
We are live.
Thank you very much. All right, good afternoon and welcome to the this remote sitting of the appeals court today. I'm going to call this case, it's our last case on the list, number 2019-1720, ANTRANNIG MINASIAN. Did I say that correctly? MINASIAN. ANTRANNIG MINASIAN. ANTRANNIG MINASIAN. Thank you very much. Versus PNC Bank National Association. Before I continue, I'll introduce the panel. My name is Vuono. I'm joined today by Justice Peter Sachs and Justice Catherine Hand. Just to remind you that you each have 15 minutes to present your argument, and there is no rebuttal on the appeals court. The same rules that apply to oral argument in the courtroom would apply to this platform as well. And lastly, in the case that we have any technical difficulties, we ask you to be patient with us. We will be patient with you. So far, we have had smooth sailing today, so I don't anticipate anything. And generally, anything that happens is resolved fairly quickly. With that said, the appellant here is Mr. MINASIAN, so Attorney Myers.
Thank you,
correct?
Your Honor. Thank you. May it please the court. Edmund Myers from Mr. Minasian. Your Honor, Mr. Minasian contends that the lower court erred on 2 points. One, that the issuance of a Soldiers and Sailors Act was a new foreclosure. And two, that the issuance of that was a basis to render to dismiss Mr. Minasian's claims as moot. A brief background of this matter, Judge, is that Mr. Minasian made claims in the lower court based on his interaction with PNC Bank during a modification process. PNC Bank is the holder of a mortgage on Mr. Minasian's property at 28 Nathan Ellis Highway in Falmouth, Massachusetts. It was based on these claims that Mr. Minasian filed his complaint in the Superior Court in 2015. Prior to filing that complaint and after the process of modification which spurred these claims, PNC Bank had issued a notice of acceleration and an intent to foreclose on the underlying note and mortgage, specifically the power of sale in that mortgage.
I think I can jump forward just a little bit if you don't mind, because we're familiar with the history of the case. And what I wanted to ask you about more specifically is after your client filed his complaint in Superior Court, and after some of the counts were dismissed by the Superior Court judge, others of course remain. The ones that remained before the case was dismissed as moot, did they all concern, in your view, as you say, all concern the loan modification process? Or in your view, did any of them concern what I'll call the impending foreclosure?
The claims focused around the modification process. Foreclosure is important to the claim because Mr. Minasian's goal naturally is to preserve the house. But they focus on the actions of PNC in the modification process. However, I would add that given how the process has come about to foreclosure, most recently what had occurred in August of 2019, it certainly may encompass part of the 93A claim. And I would add that that's not part of the argument per se here, and it may be part of my discussion later on, and that centers around the representation that was made by Attorney Volk during the
hearing on summary judgment.
For the summary judgment. And I want to be clear at the outset that when Attorney Volk made those representations, I believe those were sincere. I believe it was PNC as client that essentially hung him out to dry, if I could just use a common phrase, and left him to make those representations. Or maybe we can say there was a
miscommunication.
That's a fairer way to put it, Judge, maybe a little kinder than my client would see it. But accurate nonetheless. So going back to the crux of the matter, which is the lower court judge seeing that the notice of the Soldiers and Sailors Act, which was served on my client the day of the argument of the summary judgment, after those representations were made, as a new foreclosure. And he based, at least from the very brief and little information that was provided on the docket, that the service of this and essentially a new intent to renew the foreclosure process rendered the matter moot. And I would go back to just quickly what I referenced earlier, that PNC's right to foreclose stems from the note and the mortgage, in particular, the power of sale to the mortgage. There was only one breach, which occurred prior to the complaint being filed, and they have only one right, which is that contract, which is the mortgage. There's no new maturing of some other right or some other action on behalf of Mr. Monasian that gives them some new right or some new legal basis. Start a foreclosure. I'm sorry. Yes, sir.
Sorry, may I just get clear on what kind of relief you were requesting? As I looked at the complaint, it appeared that you were requesting not only some equitable relief regarding, this is in the original complaint, not only equitable relief regarding the then impending foreclosure, but also damages.
Yes, Judge.
Yeah. And there were a number of claims that were dismissed, I think, on summary judgment or perhaps on a motion to dismiss.
Motion to dismiss.
But the claims that survived still had damages claims attached to them, or requests for damages.
Yes, Your Honor.
Yes. So that even if a new foreclosure had been initiated in some way that made the prior requests for equitable relief against what we'll call the old foreclosure, in air quotes, moot, you still had your damages claims regarding the conduct that had occurred in the past. Is that accurate?
That is accurate.
Contention, at least?
Yes, Judge, that is accurate. And if I may, not to belabor the point, but it's an important distinction at the old foreclosure versus the new foreclosure. And I think this is where perhaps the lower court judge erred, in that there's no new or old foreclosure necessarily. There's just one right to foreclose in an ongoing process until it resolves. At least that would be my client's contention. And that resolution would be the natural flow would essentially be an auction of the property, which never occurred here. And it goes back to an anticipated argument of PNC, where they state in their brief that plaintiff referred to this notice of the Soldiers and Sailors Act as a new foreclosure. We never did that, neither in the ex parte motion seeking essentially for PNC to meet the agreement that they represented in court, or the
Does it really matter what I'm just going to ask this, does it really matter what label was put on it at that point in time? In other words,
no, it doesn't matter what label it is, Judge. I think that's correct. But I think it colors the thought process. Again, it's just one process, and it's a renewal of the same process that my client tried, that parties had agreed upon, or at least PNC did early on in the action.
Let me recap on two things just to make sure that we are on the same page, so to speak, and that is, of the remaining counts that survived the motion to dismiss in the Superior Court,
Yes.
as Justice Sachs has pointed out, of the remaining counts, my review was all of the remaining counts seek monetary damages, I could be wrong, so you can tell me. That's one. And two, that they all have to do with this loan modification process, however you want to call it. Not with actually, which is sort of the precursor of a so-called foreclosure, right? Am I right about that?
You are, Your Honor.
Okay. So what now, that being the case, that's the complaint. Let's say we agree with you. Let's say hypothetically we say the case was not moot. You have these surviving causes of action for damages. What do you say would be the procedure now? If it's not moot, of course, there's still a motion for summary judgment that hasn't, well, I guess technically on the docket it says it was denied as moot, right? Or would you be, would that be relitigated? Are you looking to amend your complaint with respect to what's happening now with the what we'll call in air quotes the new foreclosure?
Judge, I think we certainly would amend the complaint relative to PNC's activities since August of 2019. In regards to the question of what would happen next, we'd anticipate that the matter would be remanded back to the Superior Court. One, I think my client should be heard on the issue of a TRO, given the representations of PNC, so that the foreclosure, in fact, was stayed, and or I think the argument, Judge, is that when a representation is made by counsel and that there's a clear reliance on it by the plaintiff, that a TRO would be in place, that the defendant should be be required to live with that representation. In a nutshell, Judge, to do otherwise would result in an untenable result. In this particular instance, Your Honor, if PNC, which appears to be asking that the representations be ignored and that, hey, we now have this intent to foreclose, is allowed, the result is essentially that they can agree, whether it's an actual injunction or just verbally as it was here, to carry that through for a period of time, wait out the statute of limitations, and then decide, hey, we have this new intent to foreclose, and rendering everything moot. And that would actually be the result here, which we would argue certainly would be unfair in this particular instance. I would also add that as a corollary to that, as I was thinking about what had occurred, if PNC, if trial counsel actually believed that the Soldiers and Sailors Act was a new foreclosure that rendered things moot, then why go through the process of a summary judgment? Why not just, we have this new intention to foreclose, notify the court, notify plaintiff in this case, and attempt to proceed, and that wasn't done. And I think that goes to the sincerity of the argument. And I would add that, you know, they were handed what we would call this error, and they're certainly trying to press their advantage on it. I understand that, but regardless, their actions leading up to this doesn't support that this is a valid legal approach to what happened. And I would actually state that in their brief, neither in their brief nor in the judge's findings, is there any legal support for the contention that the matter is moot.
Okay.
In regards to back to what my client would anticipate happening, Your Honor, is that he would look forward to pressing his claims that remain pending, and we would probably look to re-argue the summary judgment given the distance between the arguments in present time. And lastly, Judge, the point I would make is regarding the standard of review. I wanted to touch on that because PNC is asking the court to review this as an abuse of discretion, and Mr. Monasian is asking that the court review this de novo. And on that issue, Judge, we would simply state that this is a dismissal which is traditionally reviewed de novo. There were no facts proffered by the lower court judge. There certainly was no disputed facts that the judge made a decision on. In fact, the facts are not disputed. And in this matter, the de novo standard would certainly seem appropriate.
Well, there is some fact that is disputed, because the judge does say in his endorsement that the matter is moot despite plaintiff's contentions as it relates to a foreclosure process, which the defendant has now abandoned. So the judge here is saying there was one, it's been abandoned, and this is a new one, which you do dispute, because I think your point is that this fiction of two foreclosures is the error here, correct?
Correct. Yes, Your Honor. And one of the things that struck me is I'm unsure where the judge came to the conclusion that PNC had abandoned the foreclosure process, as they did not respond to the order to show cause. Perhaps it was an assumption, but I would argue that still, I don't know if that's necessarily a dispute of fact. It still goes back to the only finding that can be gleaned from the docket is that he alleged that a new foreclosure occurred, rendering it moot. If the new foreclosure doesn't exist, then there's no clarity as to why he based the dismissal, or what legal basis he had to dismissing the claim.
I'm going to interrupt you there because I don't know if you can tell that your time has expired.
I did not see that.
I was reading your body language there. It looked to me like you were looking at some conclusionary remarks you wanted to make and hadn't seen that. So your time has expired. And so I'm going to ask you to rest on your brief unless the panel has any further questions for you. No. Okay. Thank you. Thank you very much. We'll return now and let's hear argument from Attorney Volk.
Yes, thank you, Your Honor. May it please the court. I just want to start with just a little bit of background. This loan has been in default since 2009, and no payments have been made to the bank since 2011. We're now about 9 years and 3 months since any payments have been made on this loan. This is how long this has been going on. And that default precipitated the 2015 foreclosure, which I guess we can refer to as the original foreclosure that took place. Everything that happened after that.
There was not a foreclosure.
The foreclosure process. So when I say foreclosure, Your Honor, your point is well taken. The foreclosure process that Mr. Minasian sought the injunction against, that was the 2015 foreclosure.
He sought an injunction, but he also filed a complaint and making certain allegations that were reviewed by a Superior Court judge on a motion to dismiss. Some claims were dismissed and others were not. And I can't understand why those claims that seek damages, the other claims that seek damages for breach of contract, misrepresentation, 93A, et cetera, that have to do with actions that took place during the loan modification process, not the foreclosure process, why they don't survive.
Well, my view of what the trial judge considered and decided on was that the claims relating to the modification process, which I think they're all, counsel would agree that they're all essentially related to that in itself stemmed from the 2015 foreclosure. That it all emanated from the 2015 foreclosure, and that when the 2015 foreclosure ceased and was no longer being pursued by the bank, that the trial judge.
How can you say the bank is no longer pursuing that foreclosure? It's one property, one mortgage, one. In other words, can the bank just start the foreclosure proceedings and then things go along and they dump them and start them all over again and dump them and start them again?
I'm sorry, Your Honor, I didn't mean to interrupt, but that's exactly how it happens, Your Honor. Your Honor actually just went over how it does happen. Foreclosures start, stop, and then can be restarted. And when they're restarted,
but it's all one foreclosure, is my point.
It's actually not one foreclosure, Your Honor.
Well, there are a series of notices that I know you have to send under state statutes to provide notice of certain rights to cure and seek modifications and so forth. But how does the fact that you might, and I'm not sure you've done it yet, or your client has done it yet, but even if you did send a second set of updated notices just to make sure that all the I's were dotted and T's crossed, how would that moot the claims for damages regarding what had occurred in the past unsuccessful effort to seek a permanent modification?
Well, that's the question that the trial court judge posed in his order to show cause. And it was at that point that Mr. Minasian had an opportunity to respond to the show cause order, why the case shouldn't be dismissed, why these remaining claims shouldn't be dismissed as moot. And I think if the court reviews what Mr. Minasian filed in response to the court's order, it does not include all these arguments now being made before this court. The only argument focused on whether the trial judge was mistaken, in fact, as to a new foreclosure being started. as opposed to a new foreclosure being underway, as the trial court found. And the trial court judge reviewed what was filed in response to the show cause order and still nevertheless deemed the matter as moot and the remaining claims as being moot. Now, whether the court did that because there were no arguments at the trial court level, preserving the position that these are not moot because they seek damages and they're not affected by.
How could that have happened actually in this case? This is perhaps you can help me out with this. In other words, you didn't bring any action as saying that this was moot. Clearly, obviously, Mr. Monasian didn't do that. It looks as if the judge himself, issued this order, show cause why this is not moot, right?
I can explain that, Your Honor. The trial court judge responded to what was filed by Mr. Monasian.
Oh, because of the injunction that was filed.
Because Mr. Monasian sought further injunctive relief regarding what he claimed was a new foreclosure that had been initiated. And in response to that, the judge issued the show cause order as to why the claims in this case should not be dismissed as moot. And that's what Mr. Monasian responded to.
And did PNC respond to that show cause order?
PNC did not respond because basically the trial judge was asking the parties why the case shouldn't be dismissed as moot. And PNC did not respond to that, didn't feel the need to respond to that. But Mr. Monasian did. Mr. Monasian's response was considered by the trial court. And that response is part of the record on this appeal.
So let's look at what they did, what Mr. Monasian did say in his response to the order to show cause. He says, this is Record Appendix 115, that Monasian's prayers for relief include a request that the court, that PNC enter into a reasonable loan modification with Monasian. How is that request moot, given that if a loan modification had been entered into, presumably that would make a foreclosure unnecessary?
I don't know what Mr. Monasian's position was at that time this was filed because he doesn't argue that.
Okay, no, but I'm saying he specifically says, one of my prayers for relief is I'm looking for an order to PNC to enter into a reasonable loan modification. How could that request for relief be considered moot? Regardless of whether,
as I said, I'm being asked to.
I'm sorry, I don't mean to ask you to.
No, I understand. Yeah, but my understanding is, as I said, is that the trial court judge considered those claims intertwined with the 2015 foreclosure process that had been initiated by PNC, was in response to it, and was initiated. That process was initiated as a result of the 2015 foreclosure process, and everything that transpired thereafter was related to that 2015 foreclosure process. And my understanding and expectation is that the trial court judge deemed those to be interrelated, and that if the 2015 foreclosure process was no longer proceeding, that rendered the claims relating to that as moot, regardless of whether they were seeking equitable relief or damages. And as I say, Mr. Monasian had ample opportunity to respond to the mootness issue itself, as opposed to the finding as to whether a new foreclosure was underway, and didn't avail himself of that opportunity. As a result, the trial court judge dismissed the case.
Was there anything else you would like to add in terms of your argument?
I would just reiterate what we said in our brief, is that despite what Mr. Monasian had contended, and by the way, Mr. Monasian did contend that
when you've muted yourself by mistake. You're still mute. There you go.
Unmuted.
Yeah,
I
you're
don't know
unmuted
why.
now, so we did not catch your last point.
So what I was getting at before I muted myself was that with respect to the standard of review and as to whether there were any factual findings by the court, I believe there was the factual finding that I think Your Honor pointed out, was that a new foreclosure was underway. And that was partly based on what Mr. Minasian filed with the court. In fact, the court quoted Mr. Minasian's own language back to him in its decision that he had contended a new foreclosure was underway and he was seeking injunctive relief. And on appeal, the allegation is the trial court found that a new foreclosure had been commenced, which is not the case, and I think the record bears that out. So there certainly is a factual finding that Mr. Minasian is claiming on appeal was a mistaken ruling by the trial court. And I certainly think that goes to an abuse of discretion standard on review by this court. But aside from that, I think I've addressed anything I need to address that is not in our brief.
All right, so I'm going to take a moment to see if anyone of the panel has any further follow-up additional questions. And I see that none. So I want to thank you both very much for your arguments. We'll take the case under advisement. We'll get an answer